To Aizawl bench for delivery of judgment. Item 1, WPC 139 of 2025.
Petition allowed. Impugn order set aside in quas for non-compliance of the principle of natural justice.
Deeply obliged.
Judge, amount recovered from the petitioner shall be refunded to him.
Please, your lordship. This is application under 483, lordship. Under POCSO is lordship. This TCR may be called for and notice may be issued.
Surcited case.
Charge sheet, yes, sir.
Under which section surcit is submitted?
Lordship, charge sheet is submitted on
POCSO is there.
there, yes, lordship. Charge has already been framed, lordship.
Notice has to go. POCSO is there. Issue notice. Registration call for the scan copy of the record. Fixing the matter.
2nd September.
2nd of September. On that day, Mr. Bortakur shall produce the service report. Having obtained the same from the officer in charge, jurisdiction on PS.
Obliged.
Item 2,
Please, your lordship. FIR at page 23, my lord.
Yes.
The petitioner is behind the bar for 250 days as on today, my lord. Surcit submitted. Surcit submitted. The case is in evidence stage, my lord. Evidence stage. But importantly, the petitioner number 1, who is mentally ill health, and the learned trial court has postponed her trial for her treatment. The order dated, my lord, order kindly see at page 63. It is reflected that she is mentally ill, so her trial is postponed. So ultimately, the trial is not going on, my lord, due to her mental treatment. Page 63. Page 64 is the relevant portion, para 2. In view of the above, further proceeding against the accused Nasima Bibi is hereby postponed till the recovery of her recovery from the illness. Page 64, para 2. Yes, Bortakur, what is the provision in respect of granting bail
My lord,
to
that order,
an accused who is mentally ill?
my lord, that order was passed on, my lord, 8/6/26, my lord. I will have to, my lord, get a present status report from the jail authority, my lord.
Jail authority.
Jail authority, my lord. They are involved. They, my lord, both the accused persons burned their own, my lord, newborn baby. Burnt alive.
Burned there?
Own baby, my lord, newly born baby, my lord, burned. Well, I will get any sort that I will get present health status report from the jail authority. My lord. Otherwise, if my lord sees, my lord, from the report order of the my lord, trial court dated on June, my lord, reflects that yes, she is not mentally, my lord. That is.
Heard, Mr. Your name, please. Learned counsel for the accused, and Mr. Bortakur, learned additional CP for the state respondent.
This petition under section 483 of the BNSS 2023 is preferred by accused Nasima Bibi and Ayum Ali, who are languishing in jail as in connection with Nalbari PS case number 345 of 2025, corresponding to session case number 41 of 2026 under section 103 within bracket 1, 94 and 3 within bracket 5 of the BNS 2023, read with section 75 of the Juvenile Justice, Care and Protection of Children Act 2015. Learned counsel for the accused submits that accused Nasima Bibi is suffering from mental illness for which the learned trial court has postponed further proceeding of the case and directed the jail authority for providing proper medical treatment to her in a psychiatric higher center like GMCH Gauhati or LGBRIMHS Tezpur. And he also submits that charge has been framed. Charge has been framed. That
Case is in
though
evidence.
charge has been framed and the case is pending at the stage of evidence, the witnesses could not be examined on account of her illness. And therefore, he is contended to allow the petition. However, Mr. Borthakur learned additional PP submits that the order was passed by the learned session judge on 8/6/2026. And as such, he submits that he may be granted some time to obtain instruction from the superintendent, District Jail Nalbari, regarding the present status of health of the accused Nasima Bibi. They are allowed to list the matter on
3rd September? Yes.
sorted Nalbari. It will
Yeah.
come from Nalbari.
My lord, from that order reflects that the accused Nasima Bibi may be given, she is already under the custody of the Department of Social Justice and Empowerment, my lord, for the interest of justice, although bail was not granted to her, my lord. That is therefore she is still under the custody of Department of Social Justice and Empowerment.
Not from jail.
Yeah, from 64, page 64, that is my lord, paragraph.
No, from where the report will come.
From the jail authority, I will get it
Jail
because that
authority.
is reflection is there in the order.
On 28.
28.
28.
August.
3.
Whether in respect of the other accused, whether the record will not be required.
Yes, in case of the other accused, the scan copy of TCR would be required.
Regis will also call for the scanned copy of the record from the learned trial court.
Okay. August.
483 applicants, Access and 27, 726 million. Proxo, 8, 12, and 17. At this stage, case diary and notice, Okay.
Issue notice and call for the record. Scan copy of the record from the learned trial court, fixing the matter on
27.
27th. On that day, Mr. Borthakur shall produce the service report upon respondent number 2. Next.
Now,
Wait, some serious offenses are here, like IPC and UAPA. At this stage, Lordship, CD may be called for.
What are the offenses?
Offenses put under section 134, 112, and under section 10, 13, 16, 17, 18, 20 of UAPA Act. Lordship. FIR is at page number 28.
Okay. CD be called for fixing the matter on
3rd of September.
Narayanpur.
Oh, yes.
September 1st, 2nd September.
2nd September. Lordship.
Item 5,
Similar Lordship. Similarity.
Similar.
item 6,
Similar. Lordship.
item 38.
38.
38 to 38.
4 and 5 are same. No, 4 and 5. Okay, then item 6.
6 to the left.
May I please, Your Honor? Prisoner, before Your Honor, seeking regular bail, Your Honor. The prisoner arrested on 14/7/2016, Your Honor. They are behind the bar for last 38 days. Actually, they are arrested twice for the same offense, Your Honor. And if we count from the date of their original arrest on 9/5/2026, they are behind the bar, continuously behind the bar for 101 days, Your Honor. The present affair is at page number 22, Your Honor. The file on 36/2026, Your Honor. The reference offense number ER02 of 2026 dated 21/3/2026. This is important, Your Honor. They are earlier arrested in regarding this offense number, Your Honor. May I read, Your Honor?
Not necessary.
Page number 52, earlier production, forwarding and production, 52, Your Honor.
Where is the second affair?
Second affair, intimation is a forest report, Your Honor. This was a forest report at page number 44. Offense report is same year. Year 2026 dated 21/3/2026. The accused person are same, informant are same, and they were released on default bail by the trial court on 14/7/2026. And I have annexed that order. On the same date, they were again arrested by the Biswanath Dhar River PS, only adding the section Arms Act, Your Honor. Later on, Your Honor. They were silent for last 52 days. From their initial arrest on 9/5/2026, the informant did not do anything, Your Honor. And after, when they get default bail, then they file this FIR, Your Honor, and take them custody for the same offense twice, Your Honor. This is illegal, Your Honor. They ought to have filed it on the within the, and they have also not mentioned the delay in.
No, the forest officials are not supposed to investigate a case where the Arms Act is involved.
Yeah, rule of it. But
Then,
they know that accused person are arrested on the same offense in 9/5/2020.
whatever produce the case diary.
Yes, madam.
Same offense, Your Honor. Ditto copy of the earlier offense report, Your Honor. Same informant, same accused person, Your Honor.
Maybe
The layer linguistic 38.
they cannot investigate the case under Arms Act.
But if we go to the Arms Act 51 of A, nothing recovered from them, Your Honor.
We'll say from the case diary.
Yes,
So
ma'am.
what is the case diary?
Yes, ma'am.
On sorted
2nd September.
2nd September.
Obliged, left.
Item 38. 38, my lord.
Yes.
CD, my
Yes,
lord.
there was called for, my lord, that Arunachal Assam board
Yes,
dispute.
CD is
Receive
not
it.
received, my lord. We have sent the requisition, but CD has not.
What to do
The short date may be fixed. Ma'am. We'll take next week.
next Monday?
Tuesday, my lord, would be convenient. Ma'am.
Why?
Tuesday. Because Sunday, my lord, on that day, if my lord CD not come, Monday, my lord, Sunday our office is, because on Monday, if they can hand over the CD on Tuesday.
Tuesday then.
That if it pleases to give me interim, I can appear also, record my statement.
But the offenses are serious in this.
Obliged.
On 25th. Item 7.
Please, your lordship, first of all, for the time being, lordship. The seniorism like lordship.
Item 10.
Basically, the issue involved in this case, whether the learned citizen has committed error in proceeding parallelly when the matter is same fact is pending before the learned session judge for trial, and thereby ousting the power as vested under section 358 of the BNSS upon the learned trial judge. Basically, facts is such. The respondent number 2 here
No,
has
no.
filed an-
Upon the same fact, 2 case has been registered.
No, madam. What I mean, madam, FIR has been lost, searched, and accordingly matter has been committed to the learned trial
Session
judge.
court.
Right.
Session court.
Subsequently, my lord, complaint petition has been filed by the same informant based on the same facts. Accordingly, the learned CGM has, my lord, recorded the statement under section, my lord, as per the complaint petition, my lord, and accordingly, notice has been issued to the petitioner, my lord. Now, question arises, my lord. So, for the initiation of the parallel proceeding, when the learned trials, the learned session judge has power under section 358 to call for any other person during the course of trial whose name may not be in the search sheet, my lord. If during the course of trial, if it is found that he is also involved, but his name is not there, my lord, then the learned trial judge may call the said person as an accused, and the trial may be commenced against him also. So that power has been, my lord, ousted. Is it not, my lord, the fact that the initiation of the parallel proceeding ousted the power of the learned session judge? This question has to be answered in this. If you lordship take note of the fact that the same important respondent has filed the laws the affair on the facts, basically on the count that his brother has been victimized due to the act of some minor accused persons. Wherein, my name is also there. After lodging of the affair, the police has investigated the matter and thereafter has submitted charge sheet, but my name has not been mentioned in the said charge sheet. Thereafter, the matter has been committed to the learned session judge and trial has commenced at this stage, my lord. Meanwhile, my lord, the same informant has filed a complaint case before the learned CGM, my lord. Accordingly, the learned CGM has taken, recorded the statement of the witnesses, and then, my lord, notice has been issued to me, my lord. This
Whether
is the
the
fact behind-
complaint and the search sheet and the FIR are part of this record.
Yes, sir, I have mentioned I have entire statement, even statement recorded during the course of one investigation as well as during the proceeding complaint procedure. Lordship may take note of FIR at page 29. Operative portion is at 32. Here my name is at serial number 2, my lord.
Serial number 2.
2, my lord. I am named accused, my lord.
What are the charges?
Charges, my lord, subsequently it was under section 1031, my lord, because the victim died subsequently. Initially, it was under my previous, but subsequently it died. So it was not extended.
Then where is the complaint?
My lord. Then, my lord, search sheet at page 35.
No. Where is the complaint?
Complaint it at page, my
Page
lord,
73.
71, my lord. Starts from 71, my lord. So for the paragraph number 1 to 3 were concerned, it is matter of facts which is connected with the affair. But so for the paragraph number 5 is concerned, my lord. Dear my lord, the complainant has raised objection as regards to this the charge sheet, my lord.
for not sending my name for trial.
Complainant has raised objection.
Objection in paragraph 5.
Paragraph
5 of the complaint petition. Line number, my lord, 5, my lord, of paragraph 5.
Hmm. And what order was passed by the
My lord.
CJN?
My lord, basically, White order dated 10/3/2026 is 78, my lord. The complaint petition has been entertained and subsequently White order dated 22/5/26, my lord. Page, my lord, 90, my lord. Notice has been issued after recording the statement of intent. Page 90. What happened, my lord? During the course of investigation, my lord, as many as 7 witnesses have been, my lord, examined, and 4 witnesses have been re-examined by the investigating authority, my lord. I have annexed the statement recorded during the course of my investigation at page 93, my lord. I am not in relation to the facts what they have stated before the investigating authorities as well as before the learned CJN, my lord. So far that part is concerned, it is a matter of trial, my lord. I agree with that. But so far, my lord, initiation of the proceeding parallelly with the sessions case, my lord. I am on that whether that part can outweigh the power of the learned session. Because, my lord, section 358 of 6 BNSS, my lord. Old section of 319, my lord.
Yes, Mr. Portakur,
Yes, my lord.
if any material is there against them, the session judge can proceed against them.
Session just.
Yes, my lord. There is yeah, otherwise, my lord, on the same incident, my lord, again filing of complaint and my lord, thereafter initiation of proceeding against them. May not, otherwise there are, my lord, under section 319, as he has pointed out, yes, my lord, during that session case also they can be added later on if during evidence the other witnesses or from the materials on record it is found that these accused persons are also involved in committing the murder of the deceased, then in that case also, my lord, they can be again. So otherwise, my lord, filing of complaint case again on this basis of
Same incident.
yes, my lord.
And what order was passed by the CJM when objection was raised in accepting final report against those 2 persons?
10/3/2026, page 77, my lord.
77.
My lord.
No.
My lord.
The informant has filed objection
My lord.
before the CJN
My lord.
in respect of accepting the final report filed against the 2 persons
My lord.
whose names find no mention in the FIR.
My lord.
So where is that order?
But so far that part is concerned, my lord. When the search sheet has been, my lord, submitted by the police, my lord, the matter has been committed to the learned, my lord, session judge.
No.
So-
IO might have made a pair there to discharge the other 2 persons.
My lord, that my lord, report is not so far that
No,
search sheet is there,
it
my
should be in the search sheet.
search sheet is here, my lord. I have annexed the search sheet.
Then
my lord.
record may be called for. my lord.
Page
Search
number
sheet, my lord, page, my lord, 35, my lord.
35.
Page 35.
Yes, 46 page number.
Page number
The last paragraph,
43, my lord.
46.
Yes, in particular, my lord.
Yes.
প্ৰকাশ থাকে যে এজাৰৰ নাম উল্লেখ থকা সুবোধ বিশ্বাস আৰু অজয় বিশ্বাসৰ বিৰুদ্ধে সাক্ষী প্ৰমাণ অভাৱ হোৱা হেতু তেওঁলোকৰ মোকৰ্দমাৰ পৰা ৰেহাই দিয়াৰ বাবে প্ৰাৰ্থনা জনালো।
So pair is there.
Prayer is there, মানে
And on the basis of this pair, the informant has raised objection in
Basically.
accepting this pair of the IO. What order was passed?
Yes, yes.
No. What order was passed by the
So
citizen?
for that part is concerned, I am not acquainted with. Thereafter, matter has been committed because 3 persons are there in the search.
No order was passed on this
I am
pair.
not sure, my lord, whether any order was passed because I have not. I cannot say no order was passed, my lord.
Well, let the record come
Yes,
then.
record.
Meanwhile, my lord, what happened on the 8th of September, my lord? Next date is fixed for the complaint is for appearance of the petitioner, my lord. And the moment I am appear before the learned CJM, my lord, I will be arrested and matter will be sent to trial. So,
Okay, till then further proceeding of CR case number.
Yes,
be
complaint
paid.
case, yes.
Heard Mr. Sharma, learned counsel for the petitioner. Subor Thakur, learned petitioner for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has spread for setting aside and passing the summon stroke notice dated 21/7/2026 as well as the proceeding of CR case number 31 of 2026. Mr. Sharma, learned counsel for the petitioner, submits that the respondent number 2 is the informant.
my lord,
Respondent number 2 here in this petition has filed one FIR on 13/10/2026 upon which Tongla PS case number 64 of 2024 under section 189 within bracket 2 117 within bracket 2 of the BNSS 2023 has been registered, and subsequently section 103 within bracket 2 stroke 3 within bracket 5 of the BNS 2023 was added. And after investigation, police submitted search sheet being search sheet number 1 dated 25/1/2026 against
Like records of my lord, both cases need to be come.
against my lord, Karan Kumar, Sujit Vishwas, and Nitai Sengupta.
against Nitai Sengupta, Karan Kumar, and Sujit Das to stand trial in the court. Under section 103 within bracket 2 stroke 3 within bracket 5 of BNS. And though in the FIR 5 accused have been named, yet 2 of the accused, namely Subodh Biswas and Ajoy Sengupta, have not been searched. And thereafter, upon the same fact, the respondent number 2 herein has instituted one complaint case before the learned Chief Judicial Magistrate, Udalguri, being CR case number
31 oblique
page number 31 of 2026.
71.
And upon the said complaint case, the learned Chief Judicial Magistrate by order dated page number
22/5/26, page number 90.
by order dated 22/5/2026 have taken cognizance
No, issued notice, my lord.
Where is the order of taking cognizance?
10/3/2026, page 77.
No, this is not the order of taking cognizance. This is administrative order. Where is the order of taking cognizance?
Page 77 is the order by which the case record has been received by the learned CGN, and thereafter matter has been fixed on 16/3/26 for initial deputation. Wherein manner it has been reflected, the matter has been taken, being objected.
Thereafter, by order dated 22nd of May 2026, the learned trial court, after examination of witnesses of the complainant, has issued notice to the accused persons for taking cognizance. Where is the order?
Page 90, man.
No, 90 is a notice issued, not
Notice
taking
issued.
cognizance.
Not against all the accused person, against only two persons.
No, that's all right.
Notice
Where is
was-
the order of taking cognizance?
My lord, so far that part is concerned,
22/5.
only notice was issued, we did not appear. Because it has come to.
Oh, cognizance is yet to be taken.
My lord.
Has issued notice to the respondent. No, notice to the petitioner's hearing. And being aggrieved, the petitioners approach this court by filing the present petition for quashing the complaint under section 528 of the BNSS 2023. Mr. Sharma further submits that while submitting charge sheet, the investigating officer could not collect evidence against the present two petitioners, for which he has a right for discharging the aforesaid to the present petitioners from the charges. No, from the said case. And the case has already been committed to the learned session judge Udalguri. And the case is pending at what is this?
Evidence.
Evidence is this. And that if any incriminating materials are available against them, the learned session judge has the ample power to proceed against them under section 319 R12. What is the BNS section?
358.
BNSS
358. BNS. Earlier it was 319.
358 of the BNSS 2023. And as such, issuing notice to the petitioner in the complaint case number 31 of 2026 by the learned Chief Judicial Magistrate, Udalguri is illegal and arbitrary, and therefore he is contended to interfere with the said. The submission of Mr. Sharma needs further consideration at this instance. Notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, since Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Rest shall call for the record from the learned. Call for the scanned copy of the record of session case number. Session T1 16 of 2016, 2026, and also the CR case number 31 of 2026 pending before the Court of Learned Chief Judicial Magistrate, Udalguri. So Sharma, you see, the CJM has only issued notice before taking cognizance.
My lord.
So cognizance is yet to be taken against you.
My lord. On issuance of notices itself, my lord, not punishable, because my lord, issuance of notice, my lord, taking the complaint petition for my lord, inquiry or trial, my lord, is itself, my lord,
No,
jurisdiction has
no,
been-
no, Mr. Sharma, you see, your remedy is still there. You can apprise the CJM that the session judge can proceed against them in the session case.
My lord, that application ought to have been filed with the learned session if there is any objection. So for my lord, that
No,
my
no,
lord-
no, no. You
even
can
my lord-
point it out to the learned CJM that the session judge may proceed against him or against them if materials are there.
My lord. So that on the date of moment that the complaint petition has been received, that ought to have been referred to the learned session by the learned CGM. My lord. That was not done, my lord.
No, no, there is no such provision.
And that's true, my lord. But so far that part is
But a
concerned-
session judge can so much to call for it.
may call for, my lord.
And
Then
as-
why don't you file an application before the session judge?
My lord, so far that part is
And you
concerned-
see, this petition is 528 under section.
My lord,
And my lord,
When
before
your
taking-
alternative remedy is available there.
my lord, so far that part is concerned, my lord. Entertaining the complaint petition on the same facts against the same person, my lord, on the basic, the jurisdiction and the power of the learned CGM has been seized the moment the matter has been referred to the learned session judge for trial, my lord. He has no power so far that part to deal with that part, my lord.
No.
Because it is the part only only the matter learned trial judge, my lord. Because section 358 empowers the learned trial judge even at during the course of trial to call any.
Otherwise, my lord, as per new law, without hearing the accused, even my lord, in the complaint case also, my lord, trial court will not take cognizance. My lord.
No, trial court has not yet taken
Not
cognizance.
taken cognizance, and even my lord, as per right now, my lord, as per new law, without hearing the accused, my lord.
No, therefore,
at this
notice has
point
been
also, my
issued to them.
yes, my lord.
The moment, my lord, I appeared before the learned CGM, my lord. Lordship must very
No,
much-
no,
it
without
is not
taking
triable by the
cognizance.
learned
No,
CGM, my lord.
no.
I will be, my lord, detained, my lord.
No,
And then
no.
the matter would be, my lord, committed to the learned session judge for trial, my lord.
No, without taking cognizance, the court cannot detain you.
And so far the hearing part is concerned, my lord. If I appear before the learned CGM, my lord, what happened, my lord? On that day, my lord, I participate in the hearing, my lord, and subsequently cognizance will be taken. Then, my lord, the learned CGM cannot, my lord, try the matter. So accordingly, matter has to be, my lord, committed to the learned session.
No, it will not take place in the same day, on the same day.
My lord, it is the apprehension of the petitioner, my lord.
My lord, regarding the same offense, he is already my lord, already, my lord, he is not sent up for trial.
Mm.
Then why, my lord, trial court will, my lord, now again, my lord, pass an order for arresting him, my
My
lord.
lord, so for the trial court issuance of summon to
That is in the
by the
complaint
learned
case,
trial
my
court, I have no objection, my lord. Because
So,
if the
Mr.
material,
Soma, today we will not pass any interim order. Let the record come, we will see.
my lord, what happened, my
And
lord?
also, you obtain instruction as to whether any order was passed by the CJM on the pair made by the IO in the search sheet.
My lord.
Let's shall list the matter on.
26.
For further consideration, in the meantime, Resi shall call for the scanned copy of the record from the learned from the Court of Learned Sessions Judge Udalguri, being of the session case number so and so, and also the complaint case being CA case number 31 of 2026. Interim pair of the petitioner will be considered on next date.
On 23rd
23rd of August.
of September.
No, no,
8th,
third day.
8th of September is, my lord, the next appearing date.
No.
Till then, my lord, suspended, my lord. Till my lord, written.
No. Cognizance has not been taken against you.
My lord.
2nd September.
2nd of September.
My lord.
Item 11.
Oblige you.
May I please, your lordship? If very limited prayer, lordship will have the impugn order at page 19. On lordship, on a first day itself, while the lordship, this magistrate was on leave. This petitioner lordship present, they put their signature in Hazira also. Might be because of lordship engaged lordship.
Order dated 29/5/2026.
Yes. TM was on leave lordship, but still lordship MBW has been issued against him. Now police are behind him. Very fast they lost. The case is also 323 case, 323, 294 case. IPC.
Third, Mr. Colita, learned counsel for the petitioner, Mr. Portaco, learned additional people for the state respondent. In this petition under where is the earlier order?
Either all the impunity happened. Either I have not. They have appeared also already. They already appeared. Let them go to previous bill also.
Why you remain absent on that day?
And that they lordship, the fact is that they are suggested by my client. They also ordered the present lordship. They put their signature in Hazira also. But since the court was on leave lordship, might be lordship because of this engaged counsel, since the court is on leave.
No,
Maybe next order, next that may
merely because the presiding officer was on leave.
law.
You are not supposed to file the Hazira.
Yes,
It is not
a
a
misperception lordship might be.
This petition under section 528 of the BNSS 2023 dated Article 227 of the Constitution of India. Two petitioners, namely Midul Das and Dibjyoti Bhuya, have challenged the order dated 29/5/2026 passed in PRC case number 2139 of 2022. Notably, by the impugned order dated so and so, the learned Judicial Magistrate First Class Kamrup M. Gauhati has issued non-bailable warrant of arrest against the present petitioners. Mr. Kolika submits that the petitioners are accused in what is the number of the case?
Lodge. PRC number.
PRC case number 2139 of 2022, wherein they entered appearance earlier and they were enlarged on bail. But on 29/5/2026, the presiding officer of the court was on leave, and though the petitioners remain present in the court, and also they put their signature in the Hazira, but the same, but they did not file the same in the court, for which the learned trial court has issued non-bailable warrant of arrest against them. Mr. Kolita, learned counsel for the petitioner, submits that the petitioners are ready to face trial and will appear before the learned trial court on each and every date, and therefore he has contended to recall the warrant of arrest issued against the present petitioner. Mr. Borthakur, any objection?
No, my lord.
Mr. Borthakur, learned additional PT, submits that he has no objection, but the petitioners may be directed to appear before the learned trial court on the next date. When the next date is fixed?
Lodge, which is on 2nd of December. 5th of December.
5th of December 2026. Third, having heard the submission of learned counsel for both the parties, and also taking note of the submission, also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioners to appear before the learned trial court and to apply for regular bail, or to allow them to remain on previous bail. And in the event of filing such an application, the trial court shall consider the same in accordance with law. To fix it that we can appear.
7 September.
7th of September. Until then, the non-bailable warrant of arrest issued against the present petitioners shall be kept in abeyance.
Lodge. Deeply.
Items 12.
May I please, my lord? My lord, here in this case, my lord, the three petitioners before our lordship appearing for quashing of a complaint case, my lord, filed by the respondent number 2. Here, my lord, page 32 is the complaint. A long complaint. It is the gist of the complaint is that he has lended the petitioners an amount of rupees 7 lakhs that was not paid. That is the gist of the case, my lord. It starts from page 32. These are the basic issue, my lord. Thereafter, upon receipt of the complaint, the complainant was examined under 323, my lord, page 53. Here also he has same thing. On different date, he has made payment of money. And in page 34, paragraph 9, last page, he have the total 7 lakhs. Paragraph 54, my lord, got it. So this is the case, my lord.
No, on
And-
what ground now you are approaching this court for quashing the
For
proceeding?
2 grounds, my lord.
What are the?
First is that, my lord, it is admittedly in the complaint, it is a monetary transaction between the petitioners and the complainant. So it is purely a civil nature case. Number 1. This is my first. And the number 2 is that under 225, now 225, the present petitioners, they are residing outside jurisdiction of the magistrate, my lord. They are a resident of Nagaon, and the case was instituted at Tinsukia. So what are your lordship, for a moment, kindly peruse what 225 says.
225.
225, BNSS.
Yes.
Any magistrate on receipt of a complaint of an offence of which he is under section 212 may authorized to take cognizance or which has been made over to him under 212, if he thinks fit and shall, my lord, this is the case, my lord, and shall in case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. So this section has 2 parts. First, if it is within his, if the accused is within his jurisdiction, then whether inquiry under earlier 202, it is his discretion. He may or may not. But if the accused is residing beyond his jurisdiction, here the word shall inserted. So it is mandatory on the part of the magistrate. That is not done. Here in the complaint, your lordship will find as many as 10 witnesses, including the complainant, were cited. In the complaint page, your lordship will find 35. As many as 10 witnesses, including 9 independent witnesses, excluding the complainant. None of them were examined. So this part the learned magistrate has omitted, which he is mandatorily ought to have done.
So none of the accused person in the complaint resides at Tinsukia.
They are Nagaon, and the court trying the case is at Tinsukia.
Hmm.
So all the 3 petitioners,
Hmm. So these are the 2 grounds. One
are
is
the-
civil nature and other is non-compliance of subsection 1
Your lordship,
225.
in fact, my lord, I have we have come with clean hand. The complainant has complained that we have taken rupees 7 lakhs from him.
Mm,
Your lordship will find I have given the details supporting by documents. My lord.
mm.
Your lordship will find at page 8 of my complaint.
No, we'll not go into merit of the case now.
No, just for appreciation, my lord.
Mm,
Your lord, we have in fact received from him an amount of rupees 9,36,500. But he said only 7 lakhs. And we have paid 14,76,414. Still he is demanding more money. I have made statement categorical.
mm.
I have made 4 table how those money were sent, paid and repaid, and I have annexed all supporting evidence. My bank statement, online transaction paper, everything I have annexed. For a moment, my lord, kindly peruse page 8 of my petition.
Mm.
In fact, table 1. This is the amount on various date I have made the table. Those money were paid to the bank account of petitioner number 1. Page 8, table 1.
Mm.
Page 9, table 2, those money were paid to the account of petitioner number 3. And paragraph 9, I have sum up the amount. Total is 9,36,500. And the payment I have made, page 10, my lord. We have made. There are 4 tables. Some money were paid from the account of petitioner number 1. Some were paid from the account of petitioner number 2. Some were paid to the complainant himself. Or some money were paid to the account of his wife. So 4 tables I have given, and I have this statement is given supported by document. I have annexed all document. So exclusively, my lord, it is a monetary transaction between the parties, my lord, no criminal case.
Okay,
So
let notice go at this.
at this, my lord, further till the my lord, returnable date, further proceeding may kindly be stated.
Yes, Mr. Bortakur.
Otherwise, my lord, entire financial transaction is in from the complaint detail, my lord, complaint he has that, my lord, maybe he is an accused, my lord, he may be, my lord, a resident of Tinsukia, my lord. And where, my lord, from section 225, my lord, your lordship, that is not that only because accused is a resident of India, my lord, a resident of, my lord, Nagaon, my lord, that, my lord, there is no jurisdiction of the, my lord, trial court at Tinsukia that cannot take cognizance, your lordship.
No, this is not my argument.
Your
Further,
lordship, any magistrate on receipt of a complaint of an offence of he is authorized to take cognizance or has been made over to him under section 212 may, if he thinks fit, and sale in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. So if he thinks fit, my lord, if there is, my lord, any requirement that accused is a, my lord, a permanent resident of, my lord, not within the jurisdiction of that area. Otherwise, my lord, if there are materials in the complaint that entire financial transaction is there, is in Tinsukia, those all amounts were invested in Tinsukia. Where is the requirement of, my lord, that, my lord, why the trial court at Tinsukia cannot take, my lord?
no, this is not my friend has perhaps misconstrued my argument. My argument is that I have never said the trial court at Tinsukia had no jurisdiction. That was never my argument. My argument is the 225 mandates. It is the binding duty of the court that if in case the accused is beyond his jurisdiction, then he should follow the procedure earlier 202, my lord. All witnesses should be examined. Inquiry should be conducted. Mayor examining the complainant under earlier 200. Now it is 222. That is not enough. That I have said may if he think fit, that part only if both parties are within his jurisdiction. then it is the discretion of the trial magistrate.
I mean, a huge amount of monetary transaction. my lord.
And
He has
I
collected-
have in my, with documentary, my lord, evidence, I have appeared before your lordship, my lord. I have annexed all the documents showing entire transaction.
And huge,
He paid to us and we paid to him.
huge amount of money collected from the, my lord, investors in the name of running a
And we have, my lord, paid more than 14 lakh, around 15 lakhs we have paid. $14,76,440. Monetary transaction, my lord, civil case, my lord, Supreme Court in a latest judgment, my lord, I have had this judgment, my lord, with me.
No, we are not hearing the matter on merit today.
Hmm.
Notice go at this respect.
Till then, my lord, further proceeding may be still.
They, my lord, collected
It is
huge amount,
at
huge
appearance
amount of
stage.
money in the name of running a scheme, my lord. They collected huge amount of money from those investors.
Or Mr. Yayuddin, learned counsel for the petitioner, and Mr. Bortakur, learned additional PP for the state respondent number 1 in this petition under section 528 of the BNSS 2023. The petitioner has right for causing the entire proceeding of CR case number 67 of 2026. Mr. Uddin, learned counsel for the petitioner, submits that basically on 2 grounds, the petitioner approached this court for causing the CR case number 67 of 2026. One is the dispute between the parties is civil in nature, and the other is while taking cognizance of the offense, the learned trial court has not followed the provision of section 225 of the BNSS 2023, since the petitioners are residing at Nagaon and the occurrence, and the complaint was lodged at Tinsukia. The petitioners herein are residing at Nagaon outside the jurisdiction of the learned trial court, as the complaint has been lodged before the court of learned judicial magistrate first class Tinsukia. And he also submits that the petitioner herein have paid altogether a sum of rupees 15 lakhs
14,76,440.
14 lakhs 76,400
440.
40 to
Page
the
9.
to the
Against
respondent
receipt
number
of
two,
money,
to the respondent
9,36,500.
And he has also enclosed the documentary proof of payment of the aforesaid amount. Where is the petition and the documents placed on record? Let notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, since Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week to that. Registrar will call for the record from the learned trial court. List the matter after 4 weeks until returnable that further proceeding of CR case number so and so is state.
I would like.
Item 13.
May I please, your lordship? My senior is out of station, my lord. Matter may be adjourned for
On
the
the appear being made by Mr.
Jat Hussain.
Jad Hussain, learned counsel for the petitioner. This matter is then adjourned for the day.
Highly obliged, my lord.
Item 14.
May I please, Your Lordship?
Mm.
My lord, this is an application under section 528 whereby the learned court below issued NBWA. In fact, my lord, no infirmity was committed by the learned court below.
No.
No infirmity committed by the learned court below. My lord, kindly one more chance may be given to me. I will participate.
No infirmity committed.
Page number 25, my lord.
Why you could not appear before the
My
court
lord,
on that
the
day?
victim subsequently eloped with me and both the victim and me entered into marriage and went for Meghalaya, my lord. That's why I could not able to continue my presence before the learned court. Only one more.
Heard, Mr.
A Paramanik.
A Paramanik, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the statute fund. In this petition under section 528 of the BNSS 2023, read with Article 227 of the Constitution of India, the petitioner has applied for passing and setting aside the impugned order dated 9/6/2026 and all subsequent orders by which the learned sessions has come out at Amingao issued non-bailable warrant of arrest against the petitioner in connection with special case number 18 of 2023 arising out of Baku PS case number 287/223 of 2023 under section 366 IPC. Mr. Permanent Learned Counsel for the petitioner submits that the petitioner and the victim subsequently got married, and they left for Meghalaya, and thereafter, and therefore they could not appear before the learned session judge, for which the learned session judge by order dated 9/6/2026 had issued non-bailable warrant of arrest against the present petitioner. Mr. Paramanik further submits that the petitioner is ready to face trial and will appear before the learned trial court on his and every date, and therefore he is contented to give a chance to the petitioner to face the trial. Mr. Borthakur submits that the petitioner may be directed to appear before the learned session judge and to face the trial. But taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned session judge Amingao on or before
16/9/2020. Next date is my lord 16/9/2020. Within 10 days, my lord, I will appear.
In 10 days. On 7th September.
and to apply for regular bail, and in the event of filing such an application, the learned session judge shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance.
Highly.
Turning item 7.
May it please your lordship. Well, here in this case, my lord, petitioner has 8 numbers of kettles, my lord, were seized by the Musaga police station, my lord. Subsequently, my lord, for Jima, my lord, he had prepared a petition, my lord, before the SDGM, my lord, Musaga, my lord. But that Jima petition was rejected, my lord. Lordship will find the 11 portion at page 28, my lord. And 29 is the relevant portion, my lord. Last page, my lord.
No, on the earlier occasion, you have been directed to produce relevant
Yes,
document.
my lord. Petitioner went, my lord, the police did not accept, my lord. Petitioner went to the police station, my lord, Musaga police station, but his receipt was not examined by the police, my lord. He just. In fact, my lord, till date, my lord, the police, no any other claimant has come, had approached the police, my lord, claiming those kettles, my lord. And since long, my lord, those kettles are in the custody, my lord, 17-2, my lord. Livestock, my lord, they cannot be detained, my lord, for so long period, my lord. And petitioner
Cannot be
had
detained.
17-2, my lord. 17th of
17?
February, my lord.
17?
Of February, my lord. Now it is August, my lord.
Otherwise, whether he has approached before the my lord, police station.
No, police is not
as you have
responding.
said, how can I ascertain my lord, from his submission that he has in fact?
You obtain instruction from the
I
IO.
will
My
get
lord,
it.
several occasions, my lord, they are granted time, my lord. Several occasions, my lord. Then livestock, my lord,
Because
nobody,
thereafter,
whether
my lord,
any other person has approached the police.
No,
claiming
no,
those kettles, my lord.
under which provision the cattle were seized?
My lord,
Cattle Preservation Act?
yes, my lord.
Okay, Borthakur, you obtain a report from
Yes,
the IO.
yes.
Heard Mr. Hawk, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the respondent.
Instruction.
It appears that White Order dated 23rd/7/2026. The petitioners are directed to produce the relevant documents relating to the seized cattle before the IO. And Mr. Hawk submits that on several occasions the petitioner went to the police station and produced the relevant documents, but the police did not receive, but the IO did not receive the same. At this stage, Mr. Borthakur submits that he may be allowed to obtain instruction from the officer in charge, no, from the IO concerned. And also praise for granting him some time. They are allowed. Rest shall raise the matter on Tuesday. On that day, Mr. Borthakur shall obtain instruction and place the same before the court for further consideration.
25th August.
Fine.
Item upgraded. Item numbers 45, 45 to 47 for hearing.
May it please your lordship.
Mm.
Lordship, if I may raise one copy of list of dates for your lordship.
Okay, yes.
Lordship, for your lordship's convenience, I have a one-page note on the list of dates, your lordship, which will be. I'll just touch upon few facts, your lordship, before I submit the judgment. Lordship, earlier we had submitted, your lordship, the assessment order was passed in 2018. And the complaint petition was filed for the learned court below on 5/3/2019, which I have highlighted in bold. And if your-
Furnish a copy to him also.
Yes, I have given you. And if your lordship come to the, on 15/7/22, the cognizance was taken.
Mm.
Now, in between, your lordship, the assessment order was, we went in appeal on 8/3/2019 before the Commissioner of Income Tax Appeals, Dibrugarh.
Mm.
And we got partial relief, your lordship.
Mm.
Thereafter, your lordship, we went before the appellate Commissioner of Income Tax Appeals, Dibrugarh, where the appellate order was passed. And it went right up to the Income Tax Appellate Tribunal, Kolkata bench. And the order was passed on 18/3/21. Lordship, I will just take you to the ITAT order, your lordship, that is at page number 42, your lordship, and I share it. If I may read para 3, your lordship. At the outset, learned counsel for the SSC has invited my attention to the impugned assessment order and submitted that no proper opportunity was provided by the learned assessing officer, in short learned AO, to the SSC to reconcile about the figures of account. He has mentioned in his assessment order that since the proceedings under section 143 within bracket 3 of the Income Tax Act would get barred by limitation of time, therefore he proceed to frame the assessment under section 144 of the Act, ignoring the books of account of the SSC. The plea of the learned counsel of the SSC has been that the return of income was filed online and the concerned accountant of the SSC uploaded certain documents, balance sheet of public accounts of the SSC, which were not relevant for the AY under consideration. Therefore, there was a mistake in uploading the papers of the accounts. This matter was brought to the knowledge of the learned AO. However, he did not notice the same. This plea was also raised before the learned CITA, but the learned CITA has brushed aside the plea, observing that the SSC had not pursued the case before the learned AO, and now production of reconciliation of accounts before him was an afterthought. The learned counsel of the SSC therefore has submitted the SSC may be given an opportunity so that the matter may be decided as per merits of the case. The learned counsel for the assessee therefore has requested before this tribunal that the matter may be restored to the file of the learned AO for adjudication on the issue afresh. The learned DR has not objected to the same. Lordship will kindly take note. So we have gone to the ITET, we had made the submissions, and the learned DR, the respondent, has not objected. Thereafter, in view of the above submission of both the learned representatives, the impugn order of the learned CITA is set aside, and the matter is restored to the file of the learned AO to decide the issue afresh. So thereafter, Your Lordship, the fresh assessment order was passed on 24/3/2022 by the learned AO. So the assessment order based on first assessment order, based on which the learned court below had taken cognizance, was already set aside before cognizance was taken, because cognizance was taken on 15/7/2022. Now, Lordship will kindly take note. And probably because of these kind of situation or aspect, Your Lordship, that the Parliament in its wisdom had made certain changes in the BNSS, Your Lordship, from wherein, Your Lordship, the pre-cognizance hearing was brought. Had it been a pre-cognizance hearing, we could have brought these aspects before the learned court below. But these aspects should have been placed by the respondent authority because they have already set aside the assessment order based on which the cognizance was taken subsequently. No, Lordship, I'll place. So my submission is that, Your Lordship, when the assessment order, which was the foundation, has already been gone, already been removed, Your Lordship, and subsequently fresh assessment order has been passed, and we have complied to the fresh assessment order, the penalty that was imposed, we have submitted the fine. And in fact, we have to get refund. Also, I'll place. Referring to Your Lordship, the one judgment from 2004 to SCC 731, KC Builders and another versus Assistant Commissioner of Income Tax. Lordship will kindly take up para 22, Your Lordship.
Yes.
Lordship. In the case of DL Didwani versus ITO, the prosecution was launched against the assessee for making false statement. The assessing authority held that the assessee had intentionally concealed his income derived from Y company, which belonged to him, initiating prosecution against him. The appellant filed an appeal against the assessment order, and the tribunal set aside the assessment holding that there was no material to hold that Y company belonged to assessee. The assessee thereupon filed a petition before the magistrate to drop the criminal proceedings and the application before the High Court under Section 482 to quash the criminal proceedings, which were dismissed. On appeal, this court held that the whole question whether the appellant made a false statement regarding their income, which according to the assessing authority had escaped assessment, and so far as this issue was concerned, the finding of the appellate tribunal was conclusive, and hence the prosecution cannot be sustained. Accordingly, this court quashed the criminal proceedings and allowed the appeal filed by the assessee. Now, Lordship will come to para 26. I'm relying on para 22, 26, 27 here. Para 26, if I may read. In our view, once the finding of concealment and subsequent levy of penalties under section so-and-so of the Act has been struck down by the tribunal, the assessing officer has no other alternative except to correct his order under section so-and-so as per the directions of the tribunal. As already noticed, the subject matter of the complaint before this court is concealment of income arrived at on the basis of the finding of the assessing officer. If the tribunal has set aside the order of concealment and penalties, there is no concealment in the eye of law, and therefore the prosecution cannot be proceeded with the complainant, and further proceedings will be illegal and without jurisdiction. Para 27, Your Lordship, they have certain judgments have been cited. The same view that of ours has been taken by this court and various other high courts in a setting of decision. CIT versus Bahari Brothers Private Limited held that the penalty was based on the earlier assessment order, wherein the amount representing cash credits was included. Since that order has been set aside and the cash credits deleted from the assessment, the consequent order of penalty had been rightly cancelled. Lordship will come to number 3, Your Lordship. See, this is CIT versus Bengal Jute Mills. Next page, Your Lordship. Where penalty was imposed solely on the basis of an addition of rupees 4 lakhs to SSC's total income, and the addition was deleted by the tribunal. Held that it was evident from the material on record that a penalty had been imposed solely on the basis of the addition of rupees 4 lakh to the SSC's income. If the addition was deleted, the charge of concealment of income could not be sustained. Imposition of penalty under so-and-so was therefore not valid. In our case also, the assessment order, Your Lordship, our income was held to be around 35 lakh. And subsequently, when we went in appeal, it was brought down to 11 lakhs. Anyway, Your Lordship, the ITAT has totally, Your Lordship, that order, assessment order, was set aside. And lastly, Your Lordship, para 31. It is a well-established principle that a matter which has been adjudicated and settled by the tribunal need not be dragged into the criminal courts unless and until the act of the appellants would have been described as culpable. Next, Your Lordship, I am relying on the Telangana High Court order where the
Not
instant-
necessarily, if there is a decision of Supreme Court, then why the other high courts are required?
yes, the Supreme Court judgment will suffice, Your Lordship. There's one aspect where the two questions have come double jeopardy and also violative of Article 20 within bracket. If Your Lordship will kindly take up Deccan Tobacco Processors Limited 2021 SCC online. I'll just read two
No, that is of High Court decision.
High Court.
When Supreme Court decision is there on that point, why the High Court
Lordship,
decisions are
I
required?
leave it here. Only on two aspects. In another case, Your Lordship, taken to the land, Commissioner of Income Tax, Panchkula. Another one, Your Lordship, of 2016-16 SSC 673, Commissioner of Income Tax, Panchkula versus Jai Lakshmi Rice Mill, Ambala City. Para 5, Your Lordship, I'll say short para, I'll just read it, Your Lordship.
Yes.
The tribunal as well as the High Court has held that it could not be so for a simple reason. When the original assessment order itself was set aside, the satisfaction recorded therein for the purpose of initiation of the penalty proceeding under Section 271E would also not survive. This, according to us, is the correct proposition of law stated by the High Court in the impugned judgment. So my case is that, Your Lordship, when the assessment order based on which, Your Lordship, the criminal complaint was filed has already been set aside. And also, Your Lordship, before cognizance was taken, Your Lordship, already the fresh assessment order has also been passed. And I have complied to that, Your Lordship.
Okay.
That is.
Okay. Yes, Mr. Supra.
Lordship. Lordship, first of all, let me
You'll see the decision of the Supreme Court in the case of KC Builders.
that is not applicable in my case, in this
Why?
case, Your Lordship. The facts are completely different from this case, Your Lordship, because in this case, what had happened, kindly peruse the para 22, which has been referred by Learned Counsel. In that itself, it has been decided, it says that the Honorable ITAT had decided the
case,
Mm.
ITAT had decided the appeal
Mm.
on merits, and there was no material on record found to be ascertained that there were false statements were made by the SSC.
Mm.
So the Honorable ITAT had decided the case on merits and it was completed. It was not sent back for fresh assessment and it was
Mm.
decided on merit. Number 2, para number 26, which was also referred by him. The finding of the Commissioner Appeals was struck down and hereby deleted by the Honorable Tribunal.
Mm.
So this is not a situation in our case. In our case, what had happened, which has been read out by him, Worship, they filed an appeal before the Income Tax Appellate Tribunal, in which they made a prayer that they were not given sufficient opportunity of being heard, though it was given. Honorable Tribunal just said that, okay, you go afresh, let the matter be decided on merits by the court below. The Honorable Tribunal did not go for any merits. It was a blunt, it was a directly one line decision which was given by them. In view of above, both the legal representatives, the impugned order, CIT set aside and matter is to be restored to the file of AG to decide the issue afresh. What was their prayer? Therefore, there was a mistake in uploading the paper and accounts. This matter was brought to the knowledge of the learned AO. However, he did not notice of the same. The plea was brushed out by the CIT on the observing that it was an afterthought. The learned counsel for the SSC therefore has submitted that the SSC may be given an opportunity so that the matter may be decided as per merits of the case. So the Honorable ITAT has not decided anything on merits until unless that the ground on which I have filed a prosecution, that ground has not been decided, that ground has not been brushed off by the Honorable ITAT. My prosecution and my criminal proceeding cannot be considered to have been considered to be distinct, cannot be considered to be disentitled from being proceeded further. Now, regarding the judgments, there are some certain judgment I'll be referring to, which are completely identical to our situation. The first one is, Your Lordship, 1988-41, Taxman 194. Kindly peruse the page number, the second page, first paragraph. The petitioner against whom and another the respondent has filed a complaint for offense under section 120, 193 and 420 read with section 51 of the IPC under section 277 of the Income Tax Act 1967, which is our case. Now pending before the additional CJM Madras, invoke the inherent powers of this code under section 42 to quash the above proceedings on the ground that since the original assessment of the income tax officer has been set aside by the Income Tax Appellate Tribunal and reassessment has been ordered, the very basis and substratum of the prosecution now no longer exist. These are the facts. Now, thereafter there are certain submissions.
No, where is the finding of the court?
Finding of the court. Finding of the court is in page number 8. Page number 8. It has been highlighted. May I read? Facts in the instant case, however, are entirely different from the above discussion. No doubt the tribunal has set aside the assessment and ordered the de novo assessment to peruse the accounts to verify the physical existence of the two heads of additions and to give opportunity to the petitioner to explain the source. The tribunal has not held that the entries regarding Prabhakaran are true or that the entries regarding payment of interest to the 5 persons are true. All that the tribunal has stated is that before the income tax officer could classify these two items as income from undisclosed source for making additions for the purpose of determining the quantum of tax, the physical existence of these amounts should also be verified to find out whether the first petitioner could have had other legitimate sources of income. Now, after next highlighted portion, the tribunal has required reassessment only for the purpose of finding out whether the first petitioner could have had sufficient financial resources to make these payments before concluding that these amounts could be undisclosed income. I am unable to agree with the learned counsel for the petitioners that merely because reassessment has been ordered the satisfaction originally arrived at by the income tax officer for initiating the prosecution is taken away. Now, after 2 lines, Lordship, the tribunal has not, the tribunal has also not held that the cash under those 8 checks had not been received by the 5th petitioner. In this, it is these that form the basis of substratum of the prosecution, on which the subjective satisfaction for launching prosecution could have been drawn. So here it has been decided that the particular facts and activity and the conduct and the negligence which were the basis and substratum for initiating the prosecution, those were not set aside by the tribunal. It is not in every case where the assessment order is set aside, the criminal proceeding is necessarily to be brought to a grinding halt. Certain findings of facts have to be arrived at by the tax authorities, on the basis of which they have to calculate the tax, and if some of those findings of fact have not been arrived on a proper analysis, higher forums could remand the matter for fresh consideration and for fixing afresh the extent of the fiscal liability. Such orders would not in any way affect prosecution of the offences committed with reference to
all right, do you have any others or decision?
Yes, Your Lordship, I'm having, because this decision was on the basis of a Supreme Court decision. That Supreme Court decision is also there.
Yes.
This is, Your Lordship, 1984 AIR-SC 1693, so 169.
What is the ratio?
Ratio on the last page, last paragraph.
Read it.
On careful consideration of the relevant provisions of the Act, we are of the view that a pendency of the reassessment proceedings cannot act as a bar to the institution of the criminal prosecution of offence punishable under the section 276C or 277 of the Act. The institution of criminal proceeding cannot in the circumstances also amount to an abuse of the process of the court. The High Court was therefore on the right of refusing the cost of proceeding. In our case, it is not that the proceeding is pending, though that has also been settled. One more proceeding I would like to, one more judgment.
Not necessary to multiply the decisions. That is a decision of High Court.
That is a decision of Your Lordship, Allahabad High Court.
Allahabad High Court. Not
One point
necessary.
here has been established here, Lordship,
Yes.
that the which on the last occasion Lordship had raised regarding the mens rea. This has this point was discussed by this court, Your Lordship, that in economic offences, mens rea is to be gathered from the conduct and from the surrounding circumstances, which is quite applicable in my particular case. On the one hand, they were asking for time and again that I may be given an opportunity of being heard once more before the Honorable ITO. When the matter was reassigned to the ITO, in spite of receiving show cause notice as well as notice under section 142, they did not appear before the Honorable ITO. And the matter was reassessed on that.
Okay.
So the mens
Hand
rea,
over the judgment to the court person.
I just wanted to respond.
and
to
this discusses one more thing, Lordship, that the penalty and interest proceedings and prosecution under the income tax law are two different and independent and separate proceedings. One decides about the fiscal liability, one decides about the criminal liability. So those two are not dependent on each other. In this case, what had happened, one point was raised by the petitioner, the SSC, that since the penalty prosecution is going on and I have not received any notice of penalty, so the prosecution could not be initiated. He might succeed in penalty part. So that part was completely rejected by the Honorable Allahabad High Court. That these two are completely independent and separate proceedings.
Okay. Yes.
Yes, Lordship, I just want to highlight, in the ITAD, they did not object. They could have taken the objection at that time. Now they are improved upon it. That is one aspect, Your Lordship. And second aspect, Your Lordship, is that they could have gone in appeal against the ITAD order if they were, they did not do that also. But I'll just read one small paragraph of one judgment, Your Lordship, where penalty proceedings under the income tax law are primarily quasi-criminal in nature. During their course, the rigor of the criminal law that a prosecution case must entirely stand on its own legs and not on the weakness of the defense version does not essentially operate with the infallibility. However, the onus on the prosecution in criminal matters far rigorous and must be proved beyond reasonable doubt. The defense version to be satisfactory and plausible in criminal trial is much lighter and its just way in the realm of preponderance of probability. In case, therefore, in any penalty proceedings under the income tax law, an assessed has been able to establish good and sufficient reason for the default before the commissioner and before the tribunal, can it not be said that qua the criminal trial, at least on the same facts and circumstances, reasonable cause should be treated to exist, Your Lordship? So criminal proceedings on is a higher footing where they have to, and in the case he is referring to, Your Lordship, there are additional evidences. Here, the entire case is based on the first assessment order, which is already set aside by the tribunal, which is a quasi-judicial body. That is my humble submission.
Heard Mr. Raskol, Learned Counsel for the petitioner, Mr. Supra for the respondent. Argument concluded, judgment reserved.
Much obliged, Your Lord.
Orders, ordered.
So as per the instruction I have received, my lord, the process for creation of the post, my lord, is under process, my lord. Is under process, my lord. We are waiting for the concurrence of the finance department. My lord. Once it is done, my lord, we can go ahead. Lordship will give us some more time.
When the letter was written to the finance department,
My lord, not, it is uploaded in the e-file on 19/8, my lord. 19/8/2020. The last instruction which I placed, my lord, your lordship has seen. My lord, what actually had happened, my lord, there was a confusion arisen because there were two orders of the Honorable High Court, my lord. One order of Honorable High Court, my lord, directing to place it before the SLC. When the matter was placed before the SLC, in the meantime, the petitioner again filed another petition. Now that was not brought before the court, the earlier direction. Having said so, my lord, the next direction for which this contempt has been filed, my lord, and in that when it was processed, it found that this SLC has already recommended his name. Now the subsequent direction of this honorable court against which the contempt is filed, my lord, that direction says to place it fresh before the SLC and to give a consideration. Now, since there was already a recommendation, the authorities has placed it before the verification committee, and that committee has also recommended. Now, on the basis of the earlier SLC recommendation, the process has been made. From the directors and, my lord, it has already been placed. The proposal has been penned, and this is the letter from the government, my lord.
heard Mr. Islam, Learned Counsel for the petitioner, and Mr. Kosik, Learned Counsel for the contender number 1. Mr. Kosik today has produced one letter dated 19/8/2023 of the Deputy Secretary to the Governor of Assam, addressed to the Standing Council Gauhati High Court, reprising that the proposal of the Director Elementary Education Assam regarding creation of one post for provincialization of service of the petitioner Nur Mustafa Jaman is under process through the e-file number 204568. And the said file is endorsed to the higher authority on 19/8/2026. And once the approval of the higher authority and the concurrence of finance department is received, the department shall be in a position to take consequential step to bring the matter to its logical conclusion. And on the basis of the aforementioned letter, Mr. Kosik has prideful listing the matter. After 2 weeks?
Hello.
After 2 weeks. This is list the matter on. The letter produced before the court today shall be marked as Annexer F and it tagged with the record.
How much? 10th.
Answer.
Grateful.
Item 33. May I please, Your Lordship?
Yes.
Delay continuation.
Filed objection on behalf of respondent number two, Lordship. 18 August, Lordship, not take with the.
Lordship, they have
And
not
they-
filed their objection as of yet. On last day, time was granted. Already 9 days have gone, but objection not yet filed.
18 August.
That's a condemnation or delay petition.
198 days.
Lordship.
Now, let there be condemnation of delay and we will hear the matter on merit.
Lordship.
What is the ground of the objection?
Lordship, almost 7 months, criminal petition. Full court trial, after full court trial, as the same order, Lordship. Conviction 2 months. Whereas criminal petition, Lordship, almost 7 months, Lordship.
Maybe. Heard Mr. V.S. Chaudhary, learned counsel for the applicant and Mr. Your name?
M. Alamgir.
M. Alamgiri, learned counsel for the respondent. Number 2, Mr. Goswami for the respondent number 1.
Lordship, state.
State. This application under section 5 of the Limitation Act. Read it. Section 29 of the said act is preferred by the applicant for condemnation of delay of 198 days in filing connected criminal revision petition against the judgment and order dated 14/7/2025. Passed by the learned additional session judge Barpeta in criminal appeal number 29 of 2024. Whereby the learned session judge Barpeta has upheld the judgment and order of conviction dated 29/8/2024. Passed by the learned additional chief judicial magistrate Barpeta in NI case number 123 of 2022. Whereby the applicant stood convicted under section 138 of the NI Act and sentenced to undergo rigorous imprisonment for 2 months and also to pay a fine of rupees 7,50,000 as the fine. No, not necessary. To pay a fine of rupees 7,50,000. With a default stipulation. Mr. Chaudhary, learned counsel for the applicant submits that. What is the ground?
Lordship, first, there were discussions between the family. We are family members, Lordship. There were discussions of compounding, but
2000
later on, it did not come into a fruitful result. That is why the delay was
Okay.
there.
Okay.
It's a
False
compoundable offense. That is why
Mr.
talks were there
Chaudhary,
between
learned
the
counsel
parties.
for the applicant submits that
Full submission.
the applicant and the respondent number 2 belongs to the same family.
Lordship.
And as such,
No,
they were
relatives.
negotiating to settle the
Not same
dispute
family,
amicably.
relatives, Lordship.
We are related.
Not same family, relatives.
Okay, relative.
From the,
Relative by blood or?
no relationship with,
No, not relationship.
blood relation,
Respondent number 2 niece is my husband. So Lordship, by relation of marriage.
relation of marriage, Lordship.
By relation of marriage. And they were negotiating to settle the dispute amicably, but the same failed to yield any result, and therefore, the appeal, therefore the revision, therefore this petition could not be filed in time, and the delay is not intentional, rather it is circumstantial, and he has arguable point in the revision petition, and therefore he has contended to allow the application. Per contra, Mr. Alamgiri, learned counsel for the respondent. Opposite party has opposed the petition on the ground that there is almost 7 days delay. No, 7 months delay in preferring the revision petition, whereas the punishment imposed is only 2 months. Only 2 months. Further, having heard the submission of learned counsel for both the parties, the court has carefully gone through the petition and the documents placed on record. And it appears from the submission of learned counsel for the applicant and also from the statement and environment made in the application that the delay of 198 days in preparing the connected revision petition, the connected petition stands sufficiently explained and accordingly the same stands conduct. In view of the order passed in this IA, now the registry will register the revision petition, register the petition and as the same before the court as soon as practicable.
Deeply applied. Deeply applied.
Similar to a matter, NIAC case, my lord, there's a delay of 176 days, my lord, in preparing the revision petitions.
Yes, any objection?
Yes, your lordship, I have got some objections, so I need some time to file it.
You want to file objection?
Yes, your
What objection?
lordship. The respondent, when the trial was going on, he already received a notice in his present address. But the Gaubura has given a certificate that he is no longer a resident of that particular address. But in the similar address, he has received the court summon notice. So where he was he? If somebody is relative or somebody else has received his notice on his behalf, then he was ought to have been informed that trial case is going against him.
Okay, you file objection then. Heard, Mr. Nawaz, learned counsel for the applicant. Miss, your name?
Ebora.
Learned counsel for the respondent. Miss Bora, learned counsel for the respondent, opposite parties, some states, you may be granted some time to file objection in this matter. They are allowed, list the matter on when?
Any
1
date
week?
may be fixed, your lordship.
7 September?
I need some
Can it
time,
be on
please.
8th?
8 is not possible. In the last week of September?
No.
On 9 September.
9 September. Much obliged.
Item 35. Same.
Same prayer, lordship.
Okay.
Item 44. I'm deeply obliged.
Obliged.
Item 44.
Yeah, please, your lordship.
Hmm.
Lordship, the other day on the 13th, when this matter came up, the lordship has issued a direction for stay of proceedings. On that particular day, I somehow missed out to inform your lordship that actually at present I am in jail custody. So, small inclusion,
You are in jail.
yes, as of now. Kindly, if your lordship may solemnly grant me for the time being. I somehow missed
Whether
that.
you have filed any interlocutory application? IA?
No.
No. And on the other day, you have failed to inform this court. You file one IA, then we will see.
Sorry, your lordship.
You file one interlocutory application for granting bail.
Okay.
When he was arrested.
It was last month, around 26th, last month. Exact date I don't remember. It was last month.
What is the period of imprisonment?
It was 1 year.
1 year.
Actually, your honor, the problem is that I'm a single earner of my family. I stay alone. I have 2 daughters and a wife. So nobody else is there to take care of them. Actually, if I stay inside also, it is a very big problem. At least if I get some time, I'll be able to arrange something. And in the meantime, also, I'll try to make repayments.
No, that's all right. You file one interlocutory application here for releasing you on bail. Because on the other day, the impugned judgment and orders were stayed.
Yes, your lordship. Your lordship, may I ask, if I file another petition in the session court, is that maintainable?
Pardon?
If either bail petition.
No, no,
filed
here,
in
here.
Sessions Court of
Here.
Dalbury district.
In
is it
this
maintainable?
petition. Third, Mr. Gogoi, learned counsel for the applicant. And for the petitioner. Mr. Gogoi submits that on 13/8/2026, though the impinged judgment and orders were suspended by this court, yet in the meantime, the petitioner herein was taken into custody and he has been undergoing sentence. But due to communication gap, he could not apprise the said fact to this court. And as such, he submits that he may be allowed to file one interlocutory application for granting bail to the applicant, to the petitioner. Fair allowed. So do we fix a date here?
Yes, your lordship.
Lays the matter on first week,
On third September.
3rd September,
3rd of September.
3rd of September.
3rd of
In
September.
the meantime, you file the IA.
For bail hearings, item 18, order.
May it please your lordship. Last day, lordship has made an inquiry from the public prosecutor, lordship. The date, lordship, on the day, apprehension date or the of a formal arrest date will be considered for calculation of the 24 hours, lordship. But here, my lord, after going through the record, my lord, I have flag marked all the ZD entries. The accused was produced, in fact, before the trial court within 24 hours. I can, my lord, show from the record itself, my lord. Here, my lord, some ZD entry number, my lord, 21 dated 5/7/26. 7/5/26. 7/5/26, your lordship. I have flag marked, my lord, ZD entry, all those ZD entries, my lord. Initially, information was, my lord, received at about, my lord, 11:26, 59 p.m., my lord, on 7/5/26. That information was received and one SI Bikas Dihinga was authorized to for search and seizure as per NDPS Act. That is, my lord, 7/5/26, ZD entry number, my lord, 21. Thereafter, my lord, ZD entry number 24, that is, my lord, authority letter by my lord, by the SP, my lord. Again, my lord, ZD entry number my lord, 25, dated 8/5/26 at about 12:28:35 AM. My lord, the SI, my lord, the IO, my lord, along with all other police team, my lord, proceeded towards the, my lord, proceeded for, my lord, search and seizure, my lord. Thereafter, my lord, this is one ZD entry that is important, my lord, ZD entry number 17 on 8/5/26 at about, your lordship, I have flag marked all these ZD entries, my lord. In fact, the accused person was initially produced before the trial court on 8/5/26, my lord, at about 1:30 p.m., my lord.
And arrest was shown at 11 AM on
Yes.
that day.
On 8, yes, at about 11 AM, 11 AM, yes. Thereafter, he was produced before the trial court on that day at about 1:30 p.m. Regarding that, my lord, ZD entry, I would like to read, my lord, the relevant portion, my lord. ZD entry number 17. Yes, Father. ZD entry number 17, brief on 8/5/26.
So, Mr. Sodhari, your
Yes.
contention is that you have been arrested on 7/5/2024.
He has been taken into police station on 7/5/2026 at about
My lord,
8:20 p.m.
8:20.
Yes, Lordship. Since Lordship, Lordship, I have annexed the Caesar list. That Caesar Lordship will find on page 28. Page 28. Date and time of Caesar. 7/5/2026 at 8:41
No,
p.m.
maybe time of seizure, time of arrest. These are two different things, no?
Yes. He was in the control of the police from Lordship 7/5/2026. He was not allowed to move Lordship. So, while calculating the date of Lordship, time Lordship 24 hours, my humble submission Lordship is started from the date of apprehending.
my lord,
In this regard, Lordship.
may I allowed to read one relevant portion of GD entry dated 8/5/26. That is, my lord, GD brief. On 8/5/26 at my lord 1:30, 13:30. That means at about my lord 1:30 hours. That is, now WS my lord SIP Madhuri Das along with PS staff is proceeding to Borpeta court along with arrested accused. That is on 8/5/26 1:30 p.m. my lord. Person namely Sanidul Haq, the present accused, aged about so and so, Assam, and seized articles in connection with Borpeta Road. So they, my lord, proceed to the court on 8/5/26 at about 1:30 p.m. on 8/5/26. Thereafter, my lord, one GD entry, my lord, dated, my lord, but on that day, my lord, trial court has again, my lord, that is that GD entry. There are total 5 GD entries, my lord. One, my lord, that is GD entry number 17, my lord, GD brief. On 8/5/26 at about 5:25 hours, reference to Borpeta Road PS case number so and so, Borpeta says a PS, even the Borpeta Road Malkan. It is to be mentioned here that as per instruction, it is to be mentioned that as per instruction of the Honorable CJM Court Borpeta, seizure, scene and sampling of the seized narcotic products are rescheduled, my lord. And ordered to seizure, scene and sampling tomorrow on 9/5/26. So as per the order of the learned CJM on 8/5/26, that, my lord, sampling and seizure was rescheduled on 9/5/26. In fact, the accused was produced before the trial court on 8/5/26 at about 1:30 itself, my lord. In that case, if his argument
Mr.
is
Portakur say his contention is that he was arrested on 7, not arrested, he was apprehended on 7/5/2026 at about 8:20 p.m.
My lord, in that case also, I'd like to submit in that case also, my lord, if his apprehension is, my lord, calculated from the time of apprehension also, then also, my lord, the accused person was produced within 24 hours before the court, because he was produced before the court on 8/5/26 at about 1:30 p.m. my lord. And according to him, he was apprehended, my lord. His movement was restricted on, my lord, 7/5. 26 at about 8:20 p.m. Then also from that period, my lord, 8:20 p.m. also it is calculated. Then the accused period was produced on 8/5/26 at about 1:30 p.m. That is, my lord, in that respect, GD entry is also there, my lord. So so accused was produced within 24 hours, my lord, before the trial court. From the time of apprehension also, where from when his, my lord, movement was restricted, if actual custody is, my lord, calculated from the time of apprehension, my lord, then also within 24 hours.
Lordship, kindly come to page 23, Lordship, FI. First line.
And why forwarding report, my lord, date is mentioned as 9/5/26, that GD entry, my lord, I pointed out itself, my lord, because the learned CJM itself, my lord, rescheduled the, my lord, sampling and other, and that accused person was in fact, although produced on 8/5/26 at 1:30, again, my lord, he was produced before the trial court in pursuance to the order of the learned CJM on 9/5/26.
Okay. Yes.
My friend just submit lordship, they have received an information on 8/5.
Mm.
Now lordship, their affair says. With reference to the subject cited above, I have the honor to report that on 7/5/2026 at about 6:40 p.m., one information was received by the OC Borpeta Road PS from a reliable source that one unknown person is loitering with a car at a Sadbhunir Tup area for the purpose of selling suspected codeine phosphide.
Mr. Sodore, do you have any doubt that he was not produced before the court on 8/5/2026?
Yes, lordship, the forwarding report, lordship, on the forwarding report, lordship, will see on page 42, lordship.
Mm.
Otherwise, he is not aware of all these
Nine,
entries which are
5,
available in the case diary.
and moreover, lordship, can you
That's
see
why-
that, lordship, the date was handwritten, lordship.
Mhm.
Forwarding report, lordship. Page 42, lordship.
Mm.
8/5/26.
9, the date is handwritten, lordship. Others are typed.
So here the date of arrest is shown as 8/5, not 7/5.
Sure, that is of official formal arrest, that is on 8/5 at about 11 a.m.
Mm.
and produced on the 9/5.
Okay.
Your lordship may kindly peruse this GD entry and thereafter next, your lordship, then.
No, Mr. Borthakur,
Yes, madam.
if the accused was produced before
Yes, within
magistrate
24 hours,
on
madam.
8/5/2026,
Yes.
then why this forward and date of forwarding is?
Yes, madam, that is in that respect also, my lord, GD entry, your lordship may kindly peruse both GD entries, my lord.
Mm.
This is and next page, my lord. Because in pursuance to the, my lord, that is the at 1:30 hours accused along with the accused, and thereafter, my lord, this is why, my lord, learned, this is the, my lord, GD entry regarding the direction of the learned CJM, my lord.
No, sampling was done on 9th.
Yes, my lord.
Sampling was done on 9th.
Oh, 9th, yes, my lord, 9th or 9/5/26.
So if
Reschedule,
the-
my lord, again reschedule on 9/5/26 as per the, my lord, instruction of the learned CJM. Because on that day, my lord, although accused was produced along with all, my lord, seized articles for maybe for what reason I do not know, my lord, but resampling was rescheduled on, my lord, 9/5/26. But first, my lord, GD entry was
So then the custody of the accused was not accepted on that day.
my lord, regarding that, my lord, those note, GD entry, everything is there, my lord. In fact, he was produced, my lord, accused was produced by the police before the trial, before the learned CJM. GD entry, my lord.
Then why he was again produced on 9th?
Because, my lord, as he was again sent as per the instruction of the, my lord, learned CJM, that on that particular regarding that GD entry, your lordship may kindly peruse next GD
No,
entry.
whether any order was passed by the magistrate.
Regarding that, my lord, that is not in the record, but from the, my lord, record, my lord, in those GD entries, my lord, it reflects that accused was in fact produced on 8/5/26 at about after he was arrested on 11 a.m. Thereafter, immediately at 1:30 he was produced.
No, Mr. Borthakur, do you have the order of the magistrate to show that on that day he was produced before the court?
9/5/26.
8.
Regarding 8, my lord, I have not found any order, my lord, order of the, my lord, learned CJM, but, my lord, only GD entry of the police, my lord, that is there. And, my lord, regarding other aspects, my lord, accused person has earlier, my lord, in jail, earlier he has filed 3-4 bail application before the trial court. He has never raised all these points, my lord, while filing all these bail application, my lord. And, my lord, considering that aspect also, my lord, otherwise, my lord, my first ground is that he was produced within 24 hours. Next also, my lord, that, my lord, even till date, filing of this present bail petition before this honorable court, he has never raised all these points while passing all the bail rejection order by the trial court, my lord. And he, my lord, 3-4 times he has approached before the trial court, filed bail petitions, my lord. His counsel appeared before the trial court. So right now, after a long gap of, my lord, long gap, he has
We'll
again,
pass
my
the
lord,
order. We'll examine the record.
In
Yes,
this regard,
next
also we are relying on our High Court lordship.
Not
finding.
necessary.
regarding prejudice part, I am relying by other, my lord, Sonam Raghuvanshi and my lord,
Those are there.
Darshan Kumar.
Obliged.
May it please lordship. Your Honor, request was accepted on your honor 12/4/2026, your lordship.
Okay, service report received here.
My lord, service report not received. My lord. We are constantly trying
It
to
is
get
your-
the report. Today also, my lord, I contacted my IO, has said that till now not yet served, my lord. Monday, my lord, your lordship.
Your Honor, I have filed an application, your honor, in bail petition, your honor, annexed D page 21, your honor. In this regard, your honor, I was given report, your honor, she was missing. Annexed D side load. Page
Page
number
num-
20, page
page-
21, your lordship, in bail application, annexed D. Your Honor, earlier the accused has approached the Rane trial court, your honor, and report was sought from the victim girl, your honor.
No, notice is usually
They
to
also
the
will our
informant, personal 50 submits that the IO needs 2 more days to effect service of notice upon the informant struck victim. Pair allowed list the matter on Monday. On that day, Mr. Borthakur shall produce the service report before the court.
21.
Your lordship. This is a case, two accused persons were arrested on the allegation of statement based on the accused from whom 87 kg ganja was recovered, lordship. FIR is at page, lordship. There are 13 onward.
Trial court record has been received.
Received, lordship.
So the quantity is commercial quantity.
Commercial quantity. Yes, and
But earlier it was registered under 20B.
no, lordship.
Okay,
It was
C
20,
is also there.
lordship.
Okay.
May I submit, lordship. At page 60 is the FIR, lordship. As per GD entry number 25/5/26. Page 16, lordship.
Yes.
On secret information at 4:10 PM, 87 kg ganja in 8 plastic bags were recovered from one Munia Chauhan, lordship. Specifically at page 17, lordship. Accused name is Munia Chauhan. That was on 25/5/2026, lordship. Then, lordship, please come to arrest memo at page 18, lordship. The present two petitioners, lordship, Babul Islam Khan and Israfil Islam, they were arrested on 12/6/2026, lordship, at page 18. Date and time of arrest 12/6/2026, lordship. Here, if your lordship comes to page 19, grounds of arrest, in the middle page, lordship. The previous accused person, Munia Chauhan, stated that she has purchased the contraband ganja from Babul Islam Khan and Israfil Islam, which was recovered from the previous arrested accused house.
Then 87 kg ganja was suspected cannabis was recovered from the house of the previous arrested accused. Nothing has been brought against me except the statement of the co-accused who was arrested on 25/5, Lordship. Now coming on, Lordship, the next page, Lordship, the notice under 47, Lordship, at page 21, Lordship. Detailed ground of arrest. Lordship, may I read in vernacular? It was there, Lordship. I have given the translated copy. পূর্বে গ্রেপ্তার করা অভিযুক্তর স্টেটমেন্টের ভিত্তিত আপনাক গ্রেপ্তার করা হয়েছে। যদি এনে অভিযুক্ত ব্যক্তি গ্রেপ্তার করানো হয় তেন্তে এনে ব্যক্তি অনুরূপ অপরাধত অংশগ্রহণ করার সম্ভাবনা আছে। যদিহে এনে অভিযুক্ত ব্যক্তি গ্রেপ্তার করানো হয় তেন্তে তদন্তত বাধার সৃষ্টি করার আর সাক্ষী হলক টেম্পার করার সম্ভাবনা থাকে। তদন্তের সময়ত গ্রেপ্তার করা অভিযুক্ত ব্যক্তিজনক বিরুদ্ধে অপরাধ করার পর্যাপ্ত। দিস ইজ দ্য অনলি detailed information they have given to me. From whom they have recovered, what they have recovered, what quantity they have recovered.
No, now at what is this? The case is pending.
Charge sheet has been submitted, Lordship. Evidence, it was fixed for evidence. Evidence was not recorded, Lordship.
Charge framed on
Yes,
37/26.
Lordship. Charge sheet has been
And next there was one Lordship 13/8/26 for evidence.
38/7
37/26.
search sheeted there.
Search frame.
Search sheet.
Search frame.
Search frame.
Search frame.
Lordship.
And next there was Lordship, it was gone at 13/8/26.
If your Lordship go to the charge sheet, Lordship, the trial court record, Lordship,
What is there?
nothing has been except that yes, the Munia Chauhan has stated that she has purchased this. Nothing has been recovered from me. At page 8 of the charge sheet, Lordship, in the middle portion, page 8 of the charge sheet, which may be available in the trial court record, Lordship. May I read, Lordship?
Oh, not necessary.
Yes,
Yes, except the statement of co-accused, is there any other material against him?
only
Against
the
them.
Statements of their Lordship, co-accused, arrested accused. has
Not a single witness, Lordship, has stated a single word against me.
I am asking him something.
Sorry, Lord.
She bought the contraband from this petitioner, Lordship. The statement is there, only that statements. Another CDR analysis that is not required, Lordship, because the statement is, and their confessional statement also, they are Lordship, they have been doing the business and they have supplied it to the arrested.
No, is there any documentary evidence against them
No, Lordship.
that the earlier arrested accused had purchased the same from the present accused?
That was not in the CD part, Lordship.
CD part is not available here.
Some parts are there, not just statements are there. Arrested accused and two arrested accused, that are CJA witness statements.
How many witnesses are there?
Three CJA, total PWs are 8 PWs.
Whether a statement of all the witnesses are here?
In 5 witnesses, I have got three from the CJA witness and 3 from this arrested accused.
Where is the search sheet?
I have not, it was in the trial court record, Lordship. PCR security copy has been called for, Lordship.
Mr. Goswami, you go through this Sarsit
Lordship.
and see if there is any other material or document to show their involvement except the statement of the co-accused person.
Lordship.
We will appraise this court later. We'll pass the order.
Lordship.
Lordship, can you take up my lord, item number 23 first? Same
Yes.
same person, two cases,
Mm.
but that was earlier. Well, it's earlier rejected by a lordship, man. This is a second bail application, man. Now, my lord, lordship, have a kindly look at page 20, my lord.
This may not be second, it may be fourth or fifth petition.
No, second. Before your lordship, second.
Are you sure?
Well, sure. Second, no? Second. Well, other orders have been annexed, man.
This is the seventh petition filed by the accused.
Other co-issues are there. Prabhashankar Tiwari, my lord.
Mm.
Rejection order is at page 106, my lord.
No, not seven, this is six. No, not six, this is fifth. Earlier applications were 341 of 2025,
Earlier,
1942 of 2026, and 2674 of 2025, and 3224 of 2024, and the present petition. Earlier, he was granted bail also to attend the marriage ceremony of his daughter.
my lord, in that case, my lord, I have been informed, my lord, only one case, then I may be allowed to go through the report, my lord. Unnecessary submission I will not make, my lord.
No, your submission is not based on record.
My lord. Because, my lord,
Here, rest is a notice there.
my lord.
Yes, anyway, what is the ground?
My lord, ground, my lord. First, if a lordship turns to page 20 for a once, my lord. This is BA number 1942, my lord.
Mm.
Page 20, my lord.
1942.
1942.
Second to our.
Second problem. Here your lordship will see, my lord, search cum seizure, my lord.
Page number?
Page number 2020, my lord.
Yes.
Now your lordship will see, my lord, search cum seizure, my lord.
Mm.
Name and address, my lord. Number 1, Kunal Kumar, and number 2, Imran, my lord. So these contraband were seized from other two co-accused person, not from me, my lord. Now your lordship will see, my lord, page 23, my lord.
No, you are submitting on merit of the case.
No, my lord. Well, I just want to show that the seizure was not
No,
made from-
merit you cannot, because earlier considering the merit of the case, his petition was dismissed.
Oh, man. But only I'm showing that the seizure was made from another two person.
No, that's all right. There is no doubt about it.
My lord. Now, page 23, my lord, this is the, my lord, prayer for judicial custody, my lord.
Mm. Yes.
He was arrested, my lord, on 24/9/21, my lord.
Mm.
Now, my lord, in this instant case, my lord, charge sheet has been laid, my lord. 11 witnesses were cited, my lord, and till date, my lord, 5 were examined, my lord.
Mm.
Now, if your lordship, charges were also framed, my lord. After that, my lord, out of 11 witnesses, 5 have been examined, my lord. The only ground, my lord, which I have taken in the instant case, my lord, I'm relying, my lord, page 103, my lord. Page 103, my lord, this is a notice under section 50 CRPC, my lord. Well, here, my lord, no grounds have been cited, my lord. Only it has been stated, my lord, you are hereby informed that you are arrested in connection with the above reference case and the case is cognizable and non-bailable. So you are forwarded to the court.
No, the question is after this notice, how many bail application you have preferred before the court?
My lord, I'm really sorry, my lord, and I have to go through the record. my
And
lord.
how prejudice is caused to you
My lord.
for non-compliance of this notice under section 50 CRPC
My lord. That, my lord,
in
I have to go
accordance
through.
with law?
And
How prejudice is caused to you? Because even if some defects are there,
my lord,
then you have to show that you could not file bail application before the court in time.
yes, my lord.
But it appears that on several bail application you have filed, you have not taken such plea.
My lord. Well, I have to go through the record. My lord, if I have to go through the record, my lord, Lordship may kindly grant me some time, my lord. Otherwise, I have to withdraw from the case, my lord. That instruction was not given to me, my lord.
No, now all right. They have to comply with the notice.
My lord.
Now the position is that you have to demonstrate that the prejudice is caused to you.
My lord.
If you have already filed several bail application, then how prejudice is caused to you? And this prejudice test is laid down in the case of this Sunam Raghuvamshi case.
The latest one.
Very latest one.
Yes, my lord.
And earlier in the case of that Karnataka
Darshan case.
Darshan case.
Darshan's case.
Darshan case.
And so far, the Darshan's case is concerned, my lord. My lord, our division bench of the High Court has clarified, my lord. With that point, my lord, my friend was there on the other side, my lord. Where it has been held,
NIA case as well.
that was an NIA case, my lord. Where it was held, my lord, that Vihan Kumar will follow, not the Darshan, my lord. But regard,
both are of the same.
my lord, that was the court came to a conclusion. If there is a judgment of co-equal bench of a Supreme Court, the earlier one will follow, relying upon the, my lord, Prohibitions versus National Insurance Company, my lord.
Pranay Sethi.
Sorry, Pranay Sethi versus National Insurance.
But there is a decision of Allahabad High Court that this Bihan Kumar and other decision cannot be followed because earlier there is a constitutional bench decision. Are you aware of that decision?
My lord, in fact, my lord, in the year 1956, my lord, the Allahabad High Court, my lord, allowed on this point, my lord. So for Article 21, my lord. So
Okay, then you go through the record.
Well, I will
You
go through the
show
record.
how prejudice is caused to you.
Then your
Or next
lordship will, I may have been wrongly informed, my lord. That's why, my lord, I will have to talk with the.
You go through this note of the
Yes, my lord.
registry.
Well,
Here you will got,
yes,
got
my
the
lord,
everything.
yes. And the advocates who were engaged, my lord. I am. The lordship may kindly adjourn the matter today, my lord.
Okay. Part Mr. Dr. Learned Counsel for the petitioner and Mr. RKD Sodore, Learned Senior Counsel come. Deputy Solicitor General of India for the state for the respondent. Part in part, list the matter on. When do you want?
Any date, my lord.
On 8th September.
I'll take the instruction, my lord. I'm really sorry, my lord.
May I please, Your Lordship?
Yes.
Because when the matter was earlier came for motion, my lord.
Yes.
Then your lordship was inclined to, my lord, produce one petition that was submitted before the learned court, appellate court, my lord. Which I have brought, my lord, by way of filing an additional affidavit, because earlier it was not there, my lord. So in the affidavit, my lord, it is annexure A, my lord, page number 129 of my additional affidavit. The fact of the case is that, my lord,
So you have filed one appeal.
my lord,
The appeal is pending.
my lord. So in the appeal, my lord, interim stay was granted, my lord, against the impugn order which I challenged in the appeal, my lord. But one direction was there in the order that I have to clear the area of interim maintenance, which I could not, my lord, on account of my accident. That I went for work, my lord, and while I was working, my lord, I fell down. I met with an accident. My shoulder was already fractured, my lord. On account of that since the lord, my lord, I am a wage earner, my lord, and I want to earn for money, but that I unfortunately met with an accident. So I could not earn money, therefore I could not clear the interim maintenance, my lord. So therefore, my lord, when I placed the documents and along with a petition, but having seen that I have not, my lord, cleared the interim area of interim maintenance, that the learned appellate court refused to, my lord. The interim was vacated, and, my lord, made the direction that I have to pay. Otherwise, the learned court, my lord, appellate court observed that it is not likely to take up the appeal on merit. And this is why I am before your lordship.
What wrong with that finding of the trial court?
My lord.
Session judge.
My lord.
What wrong with the order passed by the learned appellate court?
Wrong, my lord, because otherwise, my lord, I am not making an excuse before the learned appellate court that yes, I have the opportunity or I had the ability, but I could not.
Where is the application?
My lord, application, your lordship will find it page number 129, my lord, of additional affidavit. The second paragraph, third paragraph, my lord, page number 129. May I read, my lord? That as part of his commitment, the appellant went for manual work at Shillong for earning money so that he can make the payment of first installment in compliance to the terms of the order dated 29/7/2025 passed by this honorable court. But sadly to say that the appellant met with an accident at working place at Shillong on 8/9/2025.
You see, what is your pair before the learned appellate court? You come
My
to
lord.
the pair portion of the application?
Yes, here your lordship will find at page number
130.
Page number 62, my lord.
130 is the application.
My lord.
Pair, which pair?
My lord. Page number 62, your lordship will find the prayer, my lord.
No. Your pair before the appellate court.
My lord. In the appeal.
Annexure A.
Oh, yes, my lord.
Page number 129.
Yes, 130 it is therefore most respectfully prayed that your honor would be pleased to admit this petition and also be pleased to extend the interim stay granted against the further proceeding pending before the learned additional CGM Kamrup at Amingao in connection with case number DB case number 7/21, thereby dispensing with the payment of interim maintenance. So there are two petitions, my lord. Further proceeding was required to be stayed, my lord, and that, my lord, he should be dispensed with from paying the, because he was in a bedridden condition, my lord. He cannot earn now. So that was the prayer before the learned court, appellate court. Based on the petition, my lord, I have filed before the learned.
You have submitted just now,
my lord,
that you will make payment of the amount.
My lord.
But where is that averment in this application?
In this application, my lord, that particular averment, but in the appeal, I told that, my lord, I undertook that, yes, I will make the payment, my lord. That is, and on that basis, my lord, the learned appellate court passed the order.
No, in this application, your payer ought to have been to grant you some time to clear the area amount. That payer
Because,
is
my
not
lord,
there.
Since I am in a bedridden condition, my lord,
Mhm.
so how can I, because it will take
No,
time,
no.
my lord, for my recovery.
Unless a pair is made before the trial court, or no, sorry, appellate court.
Appellate, my lord.
How the appellate court would come to know that you are ready to make payment of the amount?
My lord.
Mhm.
Of course, my lord, that
Hmm.
averment is not there. But even then, my intention was that, my lord, as soon as I recover, my lord, and
No, no,
I become capable of earning, my lord.
From where the appellate court will gather your information. No, sorry, your intention.
My lord.
Unless an averment is made in the petition. Better you go and file an application before the learned session judge,
My lord.
enclosing the medical document
My lord.
and expressing your willingness to make payment of the amount and
My lord.
praying for granting some time
My
to
lord.
clear the area amount.
My lord.
And
I'll do that.
in the event of filing such an application, the trial court shall, or no, appellate court shall consider the same in a court.
My lord. I'll do, my lord. My lord.
Within a period of 6 seconds. You will appear before the learned appellate court and file an application.
My lord. Oh. Matter will be disposed of, my lord.
Yes, disposed of.
I am obliged, my lord.
Item 24.
May I please, Lord? My lord, his TCO was called for, my lord, it's received, my lord. And here is a case, my lord, suscited matter, my lord. and
This
the-
year received.
As he received, my lord. This year received, my lord.
Okay.
And as on date, my lord, 110 days, the petitioner is, my lord, in custody, my lord, and no evidence is recorded till date, my lord, after framing of charge, my lord. Your lordship will kindly come to, my lord, in fact, your lordship will kindly come to the FIR, my lord, at page 10, my lord.
You are behind the bar for
For 110 days, my lord.
110 days.
I was arrested on, my lord, 0205.
Charge was framed on
Charge was framed on, my lord, 24/06/2026.
Okay. How many witnesses have been cited in the search?
Yes, my lord.
7 PWs are there. Lordship, 7 PWs. Lordship, I have received the copy yesterday only, Lordship. I need some time to take instruction, Lordship. What
You will
instruction,
obtain
my lord?
instruction from whom? The respondent number 2.
Yes, Lordship.
Whatever is there, my lord, on the basis of the, my lord, TCA, my lord, he can, my lord, say before this honorable court.
No, when did you furnish the copy to him?
Yesterday, my lord.
Yesterday at 1 PM, Lordship.
In fact, I was not available in the court itself, my lord, for 2 days, my
No,
lord.
that's
And
all
I-
right. On the other day, on 14th, you have undertaken to furnish the
Yes,
copy to
yes.
him.
In fact, I left the court, my lord, for some reason, my lord.
Mhm.
And I came back yesterday and immediately I handed over the copy, my lord.
Let him obtain instruction then.
Yes.
Alright, Mr. Bora. Can it be on Monday?
Lordship, Tuesday.
Tuesday. Alright, Mr. Bora, learned counsel for the accused, and Mr. Kusami for learned additional PP for the respondent number 1, Mr. R. Mondal for respondent number 2. Mr. Mondal submits that only yesterday at 1 PM.
1 PM.
He has received a copy of this petition and that he could not obtain instruction, and he prays for granting him some time to obtain instruction from the respondent number 2, where allowed. Let's the matter on Tuesday.
Sir, bless.
If you. 25th August. Item 26.
May I?
Yes.
My lord, this is also, my lord, charge-sheeted case. And my lord, a scan copy of the, my lord, please receive, Lordship. TCR has been, my lord, called for last of the.
Now, Lordship, kindly see first the my lord, FIR at page 11. Page 11 is the my lord, FIR.
This is a POCSO case.
POCSO case.
Which would the respondent?
Yes,
You.
this is it. Death penalty.
Heard Mr. MZ sir, learned counsel for the accused. And Mr. Goswami for the respondent. Number 1. Mr. Goswami apprises court that CD has not yet been received. And Mr. Shah, learned counsel for the accused, submits that notice has not yet been issued to the respondent number 2 in this petition. Accordingly, it is provided that step be taken upon respondent number 2 as per notification issued by the registry of this court dated so and so within 2 working days from today, and registers shall list the matter on
31st August.
31st August.
Item 28.
And
28
on that
also
day,
we have
Mr.
received the extra service completed.
Goswami shall orders the case diary and also the service report of this part 2. Service report
Service
everything.
completed.
Received, my lord. We have received.
We have
Received.
received, yes,
Service completed.
completed.
Heard Mr.
Arey Chaudhary.
On the other day, Mr. Mazumdar appeared.
Yes, Lordship. My
Are
name is also-
Mazumdar.
Yes, Arey Majumdar and Arey Chaudhary.
Both are different person.
Yes, Lordship. Firstly, both name appears.
Okay. Heard Mr. R. Chaudhary, learned counsel for the accused, and Mr. Goswami, learned counsel, learned additional PP for the state respondent. Mr. Goswami apprised this court that service upon respondent number 2 is completed, but no one entered appearance on behalf of the respondent number 2. Accordingly, Mr. Praveen Hazarika is appointed as amicus to represent the respondent number 2. Registers shall reflect the name of Mr. Praveen Hazarika in the copies and also furnish the relevant papers to him well in advance and list the matter on
31st August.
31st August. Here, CD or scan copy?
Can copy of.
Scan copy received or not received?
Received.
Received. Okay.
Apply this.
Items 29 and 30.
Well, item number 29, 30 and 31, same PS case. Well, just before sometime we have received the CD, man. Well, your lordship may kindly take up this matter tomorrow, man. Just lately you have received the CD, man.
How many cases are there? Did you? Tomorrow.
And item 30 and 31.
Well, both, man, all, man.
All.
Interim is there. Anticipated. And 29 is bail.
Anticipatory bail.
Interim is there only in item 30.
30 and 31.
Okay, interim shall continue till tomorrow.
That-
Heard Mr. J. Ahmed, learned counsel for the accused, Mr. Portakur for the state respondent number. This is not POCSO case.
No.
Okay. Mr. Portakur submits that he has received the case diary just now. And he pressed for listing the matter tomorrow so as to enable him to go through the case diary. We are allowed to list the matter tomorrow along with AB number
823.
Item 30 and 31.
29, 30 and 31.
interim order passed in the AB number so and so shall continue till tomorrow.
Item number 40.
My lord, item number 40, my lord, we have received the report Well, IO has made an inquiry, but my lord, several attempts were made to contact the complainant through her mobile phone, but she did not receive the calls. Later also, it was also learned that complainant had already shifted to Borpeta. It was further revealed from the complainant's brother-in-law that complainant is presently staying at Borpeta and is not available at her earlier place of residence. So, my lord, IO has tried to contact a lot, but my lord, could not contact the victim. The complainant's brother-in-law was also requested to convey the message to the complainant to contact the IO. Now she is not in her earlier place of my lord, residence. She shifted.
What to do then?
Amicus maybe.
Amicus.
Amicus maybe appointed.
Okay. Part means they will learned counsel for the accused. It's about a
Proceed.
That is-
Sorry to say, Lordship. Earlier, two occasions, Lordship, in learned session board, she willfully not appeared before the court, Lordship. After
Okay,
receiving
today,
notice.
today we will engage the amicus and we will dispose of this petition.
Yes.
Mr. Bortapur submits that as per his instruction, the
This may be kept as a part of the report of the IO.
investigating officer could not serve the notice upon respondent number 2 despite his best effort, and she also refused to. No, she also did not receive the phone call. And the IO has informed the brother-in-law of the informant. And at present, the informant is staying at Barpeta and not available at the earlier place of residence. And accordingly, the IO has requested the complainants, informants or brother-in-law to convey the message to the complainant. In view of above, this court is inclined to engage N. Hassan be appointed as amicus to represent the respondent number 2.
Yes.
Rest shall reflect the name of Ms. Hassan in the cause list and furnish the case papers to her well in advance and list the matter on when? Monday?
Yes.
Monday. Tuesday or Wednesday?
Yes, Wednesday.
26th August. Item numbers 41 and 42.
Lordship, my humble apologies, Lordship, before the other side starts. Lordship, we have received the case diaries for the two bail hearing cases, but let it be placed by the Additional Advocate General, Lordship. He is currently on legs in court number 10. After some time, Lordship, if possible, the case.
We don't have mass matters. Okay, after some time.
Lordship, much obliged.
Items for admission, item 15. Please, Your Lordship. Since 482 application, Lordship may kindly peruse the last order. The final report was called for, Lordship.
As per Office Protocol 8826, final report and Lordship along with the presence of the is not received yet.
So this petition is for quashing the FIR.
FIR, Lordship. In fact,
And
Lordship, why? Yes,
IO has submitted final report here.
yes, Lordship. In fact, Lordship, while exercising their official duty, they has been, Lordship, allegedly, Lordship, implicated in a false FIR, Lordship.
No, that's all right. If there is no case against them,
Yes, Lordship.
then we can close this petition because IO has submitted final report.
No, final report, whether Lordship, whether the final report will be accepted by the concerned Lordship informant who has lodged the FIR, that's because otherwise we will have lots of difficulty because these are officers, Lordship, while exercising their official duty, they has been Lordship implicated in the false FIR. Lordship, let the reports come, Lordship, then thereafter Lordship can.
Heard,
take up-
Mr. Your name?
Gitartho Das, Lordship, G Das.
Gitartho Das, learned counsel for the petitioner, Mr. Goswami for the respondent. Office note dated
18/8/26.
8
18/8/26.
18/8/2026 indicates that final report copy being FR number 5523 has not yet been received by the registry. Accordingly, it is provided that registry shall issue urgent reminder to the Court of Learned Chief Judicial Magistrate, to the Learned Chief Judicial Magistrate Kamrup M, for transmitting the FR number 5523 to this court by special messenger, and registry shall list the matter on 31st of August.
Deeply appreciated.
May I please your lordship? I'm for item number 16 and 17. My senior is on legs in court number 22. The matters may be taken after some time.
Who is your senior?
Mr. P. Kotoki. 16 and 17. Much obliged.
37.
May I please your lordships, I'm appearing on behalf of RB Vora for respondent number 2. She's on legs in code number 3.
None appears for the appellant on call. How Miss
S. Boro.
Miss RB Bora, learned legal aid counsel for the respondent number 2 is present. So, madam, this appeal is preferred from jail.
Yes.
Is it?
Lordship, this appeal is Lordship last occasion also they have. Yes, Lordship. I have earlier occasion submitted that criminal appeal will not lie against that order, Lordship.
Not lie. But appellant is absent today. On previous date also
They
remain
have-
absent.
Yes. Lordship, the Lordship repeatedly they will.
No, we will engage one amicus to represent the appellant.
Lordship.
Then we will proceed to hear the matter.
Lordship.
None appears for the appellant on call. However, Miss RB Bora, learned legal aid counsel, is present. It appears that on the previous occasion also, the appellant remained unrepresented, and in that view of the matter, amicus is
Legal aid counsel may also appear. List of legal aid counsels from the list.
Amicus, Srimati Pratyusha Sharma is appointed as amicus to represent the case of the appellant. Registrar shall reflect the name of Pratyusha Sharma in the cause list and also furnish the relevant papers to her well in advance and list the matter on.
September.
8th of September.
Published.
The numbers 48 and 49.
These are connected second appeals, my lord. Your lordship recall that your lordship had called for the records of the case. My lord. One of the records have not come, my lord, still now.
Not come.
Your lordship.
From where the record would come?
There is an office note dated 1980, my lord, which your lordship presents.
Heard Mr. W. Hawk, learned counsel for the appellant, and Mr. Dubey, learned counsel for the respondent. Office note dated 19/8/2026 indicates that despite second reminder issued on 24/7/2026, TCR of TS number 271 of 2004 and TS number 350 of 1995 and title execution case number 1 of 2002 have not yet been received by the section till date. From where it would come?
But it has to come from the
271 from Civil Judge to Kamrup Metro. 350 from Civil Judge Junior Division 3. And title execution 1 of 22 from Civil Judge Junior Division 3. Kamrup Metro.
Okay. Accordingly, registrar is directed to issue urgent reminder to the learned courts below for transporting the aforementioned record by special messenger on or before 31st August.
yes. 3rd September.
3rd September.
3rd of September.
Deep paper.
Obliged.
Is it a parted matter?
Yes, Lord. In fact, your lordship had heard it. Lord.
Parted matter, then in the second week of September. Date second.
Eight
8th.
September.
Let me indicate in the order, Lord, it's not very clearly mentioned as such, but your lordship has heard a matter at length. Lord.
List the matter as parted.
Yes. That deep paper.
Yeah, 50.
Lordship, in my last hearing, Lordship, I talked about the contradiction of the statement of the PWs and non-compliance of section 43. Lordship, and I read judgment paragraph, Lordship, PW1, paragraph number 6 and 7, paragraph number 8, 9, 16 and 20, Lordship. Statement of informant, IO, Firostat, and the lordship, some individual, 3 individual witnesses, lordship. Lordship, in the judgment, lordship, only one point I will today explain, lordship, a little, lordship, that is PW2, lordship. PW2, lordship. Paragraph number 8 of the judgment, lordship. Mukbul Hussain, lordship.
Yes.
Lordship, in the last line, lordship, people who gathered in that area also shouted Ganja, lordship. Then police took his signature in a piece of paper as witness, lordship. Police told him that he is made a witness for the recovery of the said Ganja. In the close, lordship, he is saying, lordship, PW2 has stated that before he reached the police occurrence, about 7-8 people gathered here, Lordship. It means, Lordship, before reaching this PW, there were 7-8 people already appeared, appeared on that place, Lordship. PW2 has admitted that he does not remember the registration number of the vehicle. He did not read the content of the seizure list, which was not read over to him. He does not know how much contraband was covered from those two vehicles. Police only asked him to put his signature, and no further question was asked by the police, Lordship. I mean, Lordship, by this paragraph, Lordship, police, Lordship, has to take his signature after the seizure procedure, Lordship. And another thing is that, Lordship, he is the 9 number person arrived here, Lordship. Police did not take any signature of the another person who arrived here for the first time, Lordship, because for the first time what happened he does not know. After 7-8 person, he is the 9 number
Maybe,
person.
but the investigating officer has deposed about the same
Lordship, deposed
regarding the seizure.
police officer, it is police officer statement, Lordship.
Why should we disbelieve the police officer?
Let me see, Lordship. That is IO
PW6.
PW6, Lordship.
Yes.
PW6, Lordship, paragraph number 16, Lordship. May I read?
No, PW6 has not investigated the case. He only submitted search sheet perhaps.
Yes, Lordship. That is Shahjahan Ali.
Shahjahan Ali.
He
He is examined here.
PW1, Lordship.
PW1.
PW1. It is very contradictory, Lordship, PW1.
PW1, okay.
Very contradictory, Lordship. Lordship, in the.
Yes.
May I read, Lordship?
Yes.
Lordship. Lordship, in the paragraph number 6, Lordship, I would like to read, Lordship, page number 7, Lordship, second line, Lordship. Page number 7, second line, Lordship. He duly seized all the suspected contrabands in presence of independent witnesses, Lordship. And he paid the same and handed over the seized contraband to the Malkhana Sirostadar in presence of OC of Golokganj PS, Lordship. Lordship, in the cross-examination, he said, Lordship, Lordship, in cross-examination paragraph number 7, the second line, Lordship, he has not mentioned in the FIR which accused was traveling in which vehicle. Lordship, on next paragraph, although he communicated the higher authority regarding the search and seizure of the incident in writing, but the same is not available on record, Lordship. He communicated, but it is not available in the record. In the FIR as well as his statement recorded under section 161 of the CRPC, he did not mention that, Lordship. He duly seized all the suspected contrabands in presence of the independent witnesses and seal, peg the same and hand over the seized contraband to the Malkhana Sirostadar in presence of the OC of Golokganj PS, Lordship. It is contradictory, Lordship. And Lordship, he did not examine the Malkhana Sirostadar and OC of the Golokganj PS under section 161 of the CRPC. He admitted that he has not submitted any certificate regarding the authenticity of the pen drive deposited in the instant case, Lordship. Lordship, he also did not submit the camera used for recording the videography in the instant case, Lordship. He further admitted that, Lordship, the authorization letter does not contain the time and issue number, Lordship, of its issuance, Lordship. Lordship, he received the authorization letter on the next day of the incident, Lordship. This is another fact, Lordship. In the authorization letter, A1 was shown as a pedestrian, not as a driver, Lordship. That means I can say, Lordship, it is projected, Lordship. Pedestrian, it is projected, Lordship. Further, he admitted that, Lordship, he did not mention the name of the police persons who accompanied me in the Naka checking, Lordship. Lordship, now I would like to say something about the FIR, Lordship. In the last hearing, you asked me, Lordship. If we go to the FIR part, Lordship, the police discovered the contraband, Lordship, in the Naka checking, Lordship. And Lordship, the two vehicle collide, Lordship, with the police vehicle, Lordship. And Lordship, in the FIR, Lordship, kindly go to the FIR, Lordship, page number 14, Lordship, kindly. Of the petition, Lordship. The informant himself contravened here, Lordship. Police, the informant is an SI, Lordship, and he's saying here that, Lordship, in the middle of the first paragraph, Lordship, I underline, Lordship.
Page number? Page number?
Page number 14, Lordship. Line, Lordship.
Yes.
Line 10. 5 packets that were wrapped in plastic tape had fallen down from the broken body of the vehicle, registration number so and so, due to accident, and became clear that it was suspected to be cannabis, Lordship. The driver of both vehicle, Lordship, and two others accompanying with them were apprehended, Lordship. I informed the higher authorities about the matter over phone, and I have started the formalities of the provision under section 42 clause 2 of NDPS Act, Lordship. This is very contradictory, Lordship, because in the Lordship, when a police discovered contraband in the Naka checking, Lordship, the procedure should be done under section 43 only of the NDPS Act. But the police himself, he's saying that he followed the formalities of the provision under section 42, Lordship. This is very contradictory. This is the judgment, kindly. Please give this. There is so many judgment, Lordship, of the Honorable Supreme Court as well as the Gauhati High Court, Lordship. And this is one of the main judgment, prominent judgment. Lordship, in the paragraph number 19, Lordship, last page. Paragraph number 19, Lordship. In the instant case also, Lordship, the seizing officer, being a sub-inspector of police, was authorized to seize the contraband under section 42 of the NDPS Act, Lordship. He had no prior information or any knowledge regarding the contraband which has been seized in this case, Lordship. From the material available on record, prima facie, the case appears to be a case of chance recovery, Lordship. Further, as the seizure has been made from a good carrier, Lordship, that is transit in at a national highway, which is a public place, Lordship. This court is of considered opinion that in the instant case, provisions of section 43 of the NDPS Act 1985 is attracted and not section 42 of the said Act, Lordship. Clearly it is mentioned here. Similarly, in the judgment, Honorable Supreme Court, Kalu Khan versus State of Rajasthan, Supreme Court, similar thing said, Lordship. And Gauhati High Court, another judgment, Lordship, H. Kala Singh versus State of Meghalaya, same thing said, Lordship. But the police, here it is in the FIR saying that he discovered the contraband in the Naka checking, that is sans discovery, but he proceeds under section 42, Lordship. This is compliance, non-compliance, Lordship, non-compliance of procedure, Lordship. And Lordship, in such case, Lordship, police should proceed seizure and arrest under section 42 and 42A of the NDPS Act, Lordship only. So, Lordship, in the PW2, Lordship, so I want to say that he has been projected, Lordship, as an witness, because in the place of occurrence, he has taken the signature on a piece of paper without saying the contents of the seizure list, and he does not know how much contraband seized. And in the cross-examination also, he did not say that he has gone to the police station. And seizure done in the police
Whether
station,
those
this is not a public
contradictions are material contradiction.
Lordship.
Whether those contradictions are material contradiction.
Material, Lordship, that I have already read, and in earlier submission I have already shown, Lordship. In paragraph number, sorry, that is IO statement of IO and Sirostadar, Lordship, that is paragraph number 20, Lordship, you can see, Lord, in the judgment. That is Sirostadar, Lordship. In judgment, it is for material also, and section 52 and 52A, Lordship, it is applicable when police seized any article contraband under section 43, Lordship, in the Naka checking. This is all over my submission, Lordship, and they are the servant office master, Lordship. I already submitted. So act of master should be act of servant should be considered as the act of master, Lordship, and master has not been called, Lordship, by the honorable court in the trial, Lordship. Who is the owner of this vehicle and who is the owner of this contraband? Court never justified that thing.
No, maybe it was found in your possession.
Yes, Lordship. Lordship.
Contrabands were found in your possession.
Pardon, Lordship.
Contrabands were found in your possession.
No, it is not mentioned, Lordship.
What mentioned?
Nowhere it is mentioned that contraband found in my possession, Lordship. And contraband, Lordship, found from the engine of the vehicle, police cannot say, nobody can say, any witness can say who from which
You were
vehicle.
traveling in that vehicle?
Lordship?
You were traveling in that vehicle?
Lordship, it is, I was a driver, but it is, here it is said that he has made it pedestrian, not a driver. And which vehicle, from which vehicle contraband has been found, it is not clear anywhere, Lordship. And I was on which vehicle driver, it is not clear, Lordship. There is two vehicles, my Lordship. So I am the driver of which vehicle, police cannot say, any witness cannot say, the registration number of my vehicle cannot say, Lordship. So how?
No, is it not mentioned in the FIR, in the search sheet, and in the evidence of the IO?
No, Lordship.
PW1?
Evidence never can say that this contraband has been seized from me, Lordship. From my vehicle, not nowhere said, Lordship. And the main thing is that, Lordship, it was not a public place, the police seized and arrest me, Lordship. Another thing is that.
No.
procedure-
It has been seized during Naka checking.
Yes, Lordship, Naka checking, but procedure should be maintained, Lordship.
What procedure?
43, that one.
Yes, what 43 says.
43, seizure and arrest must be in public place,
Hmm.
but seized in the police station, Lordship,
Hmm.
at the midnight, Lordship. And the.
No, what wrong with that? They have
PW
taken the, after detecting the seized articles, contraband articles, they have taken you and the vehicle with the contraband substances to the police station, and there they have seized it.
Yes, Lordship.
What wrong with that?
Wrong with that, that means, Lordship, police station is not properly a public place, Lordship. It is a restricted area
Hmm.
and general public cannot
No,
interact there.
is it the mandate of section 43?
Yes, sir, Lordship.
Hmm.
In the explanation last line, Lordship, it is clearly mentioned in the 43.
Hmm.
Public place means any convenience,
Hmm.
hotel, Lordship, then bus station like this, Lordship.
Hmm.
But nowhere it is written that police station is a public place.
No, where it is stated that it should be seized in public place.
It should be, Lordship, in section 43, Lordship.
You read it.
Section 43, I have no that one, Lordship. I have no the clear text, Lordship. Lordship, I have given a judgment in my earlier hearing, Lordship. It is clearly mentioned here.
Regarding?
The name of the judgment is, Lordship,
Mhm.
regarding 43. Section 43. That is, state of Punjab and Balbir Singh, Lordship.
Which paragraph it is stated?
Lordship. To 9. In the case to 9, we are to 9. Also, may I go for the BRF, Lordship?
Hmm.
43, Lordship.
Hmm.
In the last paragraph, let's say explanation, Lordship.
Hmm.
43, last paragraph.
Yes.
For the purpose of this section, Lordship,
Hmm.
the expression public place
Hmm.
includes any public conveyance, hotel, shop,
Hmm.
other place intended for use by or accessible to the public.
No, my question is where it is mandated that the seized articles, the contraband articles to be seized at public place.
Lordship, it is here, Lordship. It is in the headline, it is written, Lordship. Power of seizure and arrest in public place, Lordship.
Hmm. No, is it mandated that it should be in the public place?
Yes, Lordship.
Where?
I am given judgment, Lordship.
Hmm? If we were not ready today, let us adjourn the matter.
Lordship, this is all over my submission.
You
Lordship.
come prepared, then
And-
you show the actual provision. Yes, Mr. Sharma.
My lord.
Is it the mandate of section 43 that it should be seized in public place?
My lord, in the my lord, section itself, my lord,
Hmm.
the power of seizure and arrest in public place.
Hmm.
No, my lord, I'm reading, my lord. Seize in any public place
Hmm.
or in transit
Hmm.
any narcotic, drug or psychotropic substances or controlled substance in respect of which he has been reason to believe an offense punishable under this act has been committed.
Hmm.
So, my lord, public place must be in 43, my lord, the public place.
Hmm.
And my lord, in 42, it is in
Okay.
private house, room or otherwise, my lord, vehicle.
No, is it mandated in the section that it should be, the article should be seized in the public place?
Now, my lord, plain reading, my lord, it seems that it should be in public place.
Hmm.
Yes.
But my lord, police station is also a public place, my lord.
Hmm.
It is a public office, my lord.
Hmm.
Yeah. Yes, yes. My lord, the reason is itself described in my lord FIR. Because my lord, some skilled person is required, my lord, because to break the, my lord, that vehicle. My lord, kindly have a look, my lord, that FIR. I am reading, my lord, the last para.
Hmm.
The FIR. my lord. Last para.
Yes.
As there was not enough light at that place and both vehicles are carried a lot of substance cannabis hidden inside its body and needs a skilled person to open the body of the vehicle number such and such and a vehicle registration number. There are two vehicles. I have informed the higher authority about the traffic congestion has been created in exchange of the for the accident and need for more time and sufficient lighting to observe all formalities and according to the suggestion of the higher authority, I have arranged to lifting the both accidental vehicle to the Golokganj police station driven by driver namely Raju Chaudhary, son of such and such, and my address being present at that place. The three independent witnesses were told to come to us to the police station and agree and come with us to the Golokganj police station. Accordingly, two vehicles were brought to the Golokganj police station and I, along with the independent witnesses, reached to the PS and after
reaching PS, the following vehicle mechanic, skilled person, were called to open the body of the vehicle, both the vehicle, my lord. Skilled person also named. There are two skilled person, Vishwajit Roy and my lord Nur Islam. They have opened. So, my lord, that reason is also given, my lord. And from the, my lord, both the vehicle, my lord, the contraband was seized, my lord. If from each vehicle, what quantity seized, my lord, that is also clearly mentioned, my lord, in the FIR. That is also clear, my lord. In the second page, my lord, that by the weighting, that's are by weighting and counting, it is found that 35.126 kg in 9 packets were recovered from the body of the vehicle bearing registration number 6256 and 31.713 kg in 88 packets recovered from the body of the vehicle bearing registration number, it is, my lord, 4199, totaling 66.899 in 177 packets. It is clearly mentioned.
Lordship, regarding my submission, regarding this statement, I have a submission, Lordship. Police contracted the driver to shift the vehicle from highway to police station and call the mechanics also, but no mechanic or no driver has been made in witness. Lordship. It is one such, Lordship. And main another thing, police did not follow Article 43, 52 and 52A, Lordship. Should be arrested under section 43. 42 is not is absent in this case, Lordship. The judgment said-
when section 43 is applicable,
Yes, Lordship.
42 is
It
not
judgment-
required to be complied with.
Lordship, judgment clearly said in this case, in the Naka checking, when any chance recovery there, 43 never should be applied. Only
Never
40
applied.
43 is applied. In the judgment, I have already recently read, Lordship. Paragraph number 9.
Then, okay, we'll list the matter further for hearing. Mr. Sharma, you come prepared? In respect of which of the provision, 42 or 43 you will
Yes,
attend here?
Paragraph 19 I have.
And regarding contradiction,
Yes.
in the evidence of PW 2, 3 and 4,
And
and
this contradiction also.
recovery from 2 vehicles, whether it has been proved or not.
Some discrepancies are there, my lord, but some discrepancies are there, my lord. But, my lord, ultimately, these contrabands were recovered from the 2 vehicles. And, my lord, this petitioner traveled
The 2
in
vehicles,
one of
that
the
all right, whether the vehicle, whether same has been proved or not, you have to satisfy this court on next day.
ultimately,
Heard
my-
Mr. M. Rahman,
Yes, sir.
learned counsel for the appellant, Mr. B. Sharma, learned additional PP for the respondent. List the matter on
10 September.
10th of September for
10 September, Lordship.
further hearing.
Lordship, if possible, kindly give a short date. I would like to finish like this, because it is 4th year going.
Maybe. Before that, it is not possible.
Pending items 41 and 42.
Otherwise, Lordship, my part has been finished, no?
No,
No.
41 and 42.
He will reply to your submission.
Otherwise.
Well,
Please, Your Lordship, application for regular bail. I was arrested on 5th of August and in custody for last 16 days, my lord. This is the GST fraud matter, my lord. A number of cases have been filed. Now, before I take your lordship to the FIR, lordship may kindly come to page 14. This 14 is a document which was dated 21st of May 2025. On that day, a raid was done, my lord. A raid was done in the premises of Shahina Sultana. This order was passed authorizing some inspector. This was on 21/5/2025. Now your lordship may kindly come to the FIR, which will be at page 20, my lord. Relevant page will be 20, my lord. It started at 16. Now this FIR was filed after about 1 year. In the meantime, hearing and investigations were going on. So it took about 1 year to file the FIR. And page 23 of the FIR, my lord. Lordship will find 3 names are there, my lord. Deepak Shah, Shahina Sultana, Amit Kumar Jha, my lord. Now it is Amit Kumar Jha was described as the mastermind behind everything, my lord. Now what I mean to submit, my lord, this FIR which was filed after 1 year of investigation, in the entire FIR, my name is not there. I was an employee in, there are 3 firms involved there, my lord. Ida Bitumex, Barrel Bitumen, and Assam Bitumex. I was only an employee there, and subsequently I was working as a commission agent, my lord. Now, almost, my lord, my instruction is that almost all those have been arrested, except this 41 and 42 matter, my lord, all have been granted bail. 4 bail petition I have orders passed by this honorable court have enclosed here, my lord, including that Amit Kumar Jha, who was released after 38 days, who was said to be the mastermind. Now, page 55, 58, 62, and 66. Lordship, my lord, kindly consider the case diary, my lord, whether further detention of the petitioner is required, my lord.
Mr. Gogoi, case diary is available.
yes.
So
First
is
of-
there any material against the present?
Yes, my serious, but they are the main one, my lord. In this entire, my lord, criminal case, my lord. I will place the case diary, lord, you will kindly peruse their statement. In fact, today a statement has been made that, my lord, Amit Kumar Jha is the main one, my lord. He was an advocate. He registered the funds and all. For that, he was arrested. My learned
My lord,
senior-
they have
senior
mentioned in the
colleague-
document that he is the mastermind.
No.
That's why I
It's a
said, my lord.
different thing. Ultimately, he got the bail on that count only. Now, Lord, we will see, my lord, the statements of the present petitioner. That is Binit Poddar. He has been arrested recently. The other one is there, my lord, for about 3 months. I have flag marked it, Lord. We will kindly have a look at. Binit Poddar. Before that, my lord, may I point out, my lord, the statement of the, my lord, informant or the complainant, my lord. He is the, my lord, main tax authority. His statement, my lord, will reflect everything. Lord, we will see the statement of Binit Poddar then, my lord. The petitioner hearing. Binit Poddar. Down below, Lord, we have seen, my lord, serial number 2.
How many statements are there?
My other statements are there. He has been arrested recently, my lord. This is the latest one.
No, I have seen 2 statements of Benit Poddar.
No, Lord, we will see the second one.
Second one.
Yes. The flag marked. May I read the first one? Same thing, but let me read the first one. It is dated, my lord, 7/8/2026 at the top. Serial number 2. My name and address, as stated above, are true and correct. I state that I have been associated with Sebas Haider, the other petitioner, bail applicant, and Rajesh Kumar Pintu Sharma since the year 2001. We initially started the firm Ida Bitumen. Now he is saying he's an employee there, but this is his own statement. We initially started the firm Ida Bitumex in 2001. Gradually, again, my lord, we started the firm, another firm, Barrel Bitumen and Assam Bitumix. And together we ran the business of Ida Bitumex. His own statement, my lord. Barrel Bitumen and Assam Bitumex. The firm Ida Bitumex was registered in the name of Sebas Haider's wife.
Sahina Sultana, she has been granted bail. MS Beryl Bitumen was registered in the name of Deepak Shaw of Kolkata, while Assam Bitumex was registered in the name of Jitendra Shaw of Kolkata. Deepak Shaw and Jitendra Shaw are brothers. They allowed us to use their funds for our business, and in return, each of them received a commission of 5,000 per month. Lord, you will remember, my lord, one was doing that flower business. I don't know who facilitated in making of these three firms. Although the firm was registered in different names, all three firms were operated and managed by me. Sebas Haidar, that is other petitioner, and Rajesh Kumar, that is Pintu Sharma. I was not involved in preparing the purchase or sale of bills of the three firms. The responsibility for preparing such bills were with Sebas Haidar and Rajesh Kumar. The profits obtained from the business was divided equally amongst us. Amongst me, Sebas Haidar and Rajesh Kumar. My role was to look after the sale, and I used to receive an extra 10% or 20% of the profits earned from the sales as my commission. Mohammad Nosad, a resident of Bihar, whom Sebas Haidar had introduced to me as his cousin, also assisted in preparing the purchase bills of the three firms at times and used to get some commission out of the profits. I was also responsible of getting the sale bill made through our CA. Sebas Haidar and Rajesh Kumar were responsible for getting the purchase bills made. Ajay Yadav was the caretaker of all the three firms in Gauhati. He used to keep stock of all the bills and files in Gauhati. That's all I have to state. Now here he has blamed that, my lord, it is Sebas Haidar, my lord, who used to prepare the bills. Sebas Haidar, I will place the statement, he states that, my lord, it is the Vinit Poddar who used to prepare the bills. Now, my lord, the next statement of the, my lord, I have flag marked. Here also, my lord, my name is so and so, is true and correct. I would like to state that I am a commission agent by profession. Previously, I was into textile business, but after the COVID pandemic, I got in connection with Sebas Haidar. Though one of my through one of my brother-in-law, I have been associated with Sebas and Rajesh Kumar since 2001. I would like to state that I along with Sebas Haidar and Rajesh Kumar were together running the business of Ida Bitumex, Beryl Bitumen, and Assam Bitumix. Sebas Haidar was responsible for making the purchase of bitumen related to all the three aforesaid firms, and I was responsible to finding the clients for sale. I am not involved in making the bills of the purchase or sales. Sebas Haidar and Rajesh Kumar, Pintu Sharma were responsible for making such bills. Previously, till about 2022, I worked as a salaried employee of Sebas Haidar. After that, I observed that Sebas and the other associates have been making huge profits compared to me. So I started taking commission from the profits instead. After that, I used to get a commission of 10% and sometimes 20% from the profits of the aforementioned three firms. Mohammad Nosad of Bihar, who Sebas Haidar had introduced to me as his cousin, was also engaged in making the bills for purchase shown between the aforementioned three firms. The firm Ida Bitumex was registered in the name of Sebas Haidar's wife, Sahina Sultana, whereas the firm Beryl Bitumen was registered in the name of one Deepak Shaw from Kolkata, and the firm Assam Bitumex was registered in the name of one Jitendra Shaw from Kolkata. Both Jitendra Shaw and Deepak Shaw are brothers, and both of them used to get a commission of rupees 5,000 per month in exchange for their lending their registered firms named to us for use of our business. Me, Sebas Haidar, and Rajesh Kumar used to operate all the three firms, so and so. That's all I have to say. So, in a sense, my lord, he has admitted that he is there actively involved in the operation of the firms.
No, whether investigation is about to complete or
He has been
it is still
arrested.
going on.
My lord, still, my lord, this one person has probably, one or two has not been arrested till now. They have absconded. Their own account, my lord.
Whether the investigation so far the present accused persons are concerned is completed or it is going on.
Well, moment the other accused are arrested, they are being the main accused, my lord. They will be required, my lord, to interrogate, my lord. Of
No,
course.
in that event you can call them.
Well, he has been arrested only in, my lord, 6-8 recently. 4 or 5, yes. this month. Other one, my lord, lordship will peruse his statement also, my lord, Sebas Haider, what he has stated against this petitioner, my lord.
Okay, I will go through the same. Okay.
And
Well, only one thing, my lord, Lordship kindly see.
And lordship may kindly, may I submit, my lord? So far as, my lord, the statements of the main informant, the tax official, lordship may kindly see, my lord, huge amount of money has been plotted. These are all, my lord, revenue, my lord, of the state, not only of the state, my lord, GST is for the country itself. Only a portion is given to us. They have flouted, my lord, by all means, my lord, and fraudulently, my lord, they took, my lord, benefit of, my lord, all the, my lord, false transactions, my lord, by input tax credit, my lord,
Okay.
amounting to crores of rupees.
My lord, one aspect of the matter, my lord, just 1 minute, my lord. All the owners of these farms, they have been granted bail, my lord, in this case. That they are the main thing. And then, my lord, I was in police custody.
Mr. Chakraborty, you say those were not real owners.
Yes, lordship has seen their statement. And
As per the materials collected in the case diary,
No, they were arrested, my lord. They have been released on bail, my lord. They said
they were not the actual owner.
no, there is a my lord, there is a fraud. I'm not saying that there is a huge fraud, my lord. But thing is that, my lord, the actual owners who were arrested have been released on bail, my lord. Almost all have been released on bail.
No, in their name, the farms were
And I was on custody
registered.
for 5 days, my lord. So thereafter, Lordship kindly consider further detention may be necessary.
Okay, we'll see.
Lordship, please. Item 42, madam.
Yes.
Shahbaz Haider.
67
I was
His
arrested-
wife was granted bail.
Yes, madam, absolutely right. And I was arrested on 14/6/2026. 14/6. Bihar. Then 16/6 I was produced.
Yeah.
So there are two companies, my lord, here. Rather they are firms, they are not even companies. So my learned friend had just said that we are partners. I mean, there were partners who were doing business. One is blaming me and the other is blaming someone else. In this context, my lord, either Butimex, which is run by a proprietorship concern, which belongs to my wife, your lordships has already granted bail on that. Would your lordships be kind enough to come to page 57? That was the application that was filed before the lower court, my lord. Page 67.
Yes.
This is an application filed under section so-and-so, named Shahbaz Haider, who is the petitioner before your lordships, to go on bail in connection of case number who was arrested on 14/6/2026. Then, my lord, the grounds that we have arrest have been made at page 76, bottom. Page 76, last two lines, my lord. On the other hand, the learned prosecution objects the bail prayer on the following grounds. Number one, the offense is a serious economic offense involving fraud upon public exchequer and loss of revenue running to several crores, that is more than 47.71 crores. It is to be noted that a murder may be committed in the heat of a moment upon passion being aroused, whereas an economic offense is committed with a cool calculation and deliberate design with an eye of a personal profit, regardless of the consequences of a community. Number two, economic offense constitute a distinct class of offense affecting the financial health of the state and therefore requires strict consideration. Now, the third is very important, my friend. Shahbaz Haider is a de facto manager of Ida Butimex. Now, we are concerned with the same firm in which the wife has been already been granted bail by your lordships, which is registered in the name of Shahina's wife, Shahima Sultan. The firm, next page, my lord, has availed input tax credit amounting to 7 crores. Amount is so-and-so by fraudulent means and forged invoices which were detrimental to the national economy. Shahima Sultan has also been arrested in connection with the case and presently in judicial custody. Next paragraph, my lord. Shahbaz Haider, along with the other associates who has jointly operating 2 or more additional firms, Beryl Bitumen and Assam Bitumex, Messrs. Beryl Bitumex fraudulently avail input credit tax of so-and-so. Now the word is extremely useful. By using forged invoices and other fraudulent means. So the entire allegation in the FIR of creating a false document, taking an advantage is not available in my case. It is of using a forged document which is already being created in existence. For that, all that my learned friend has to do is perhaps go into all the documentary evidence that has been collected from 2024, 25, 26, whatever they has been collected. If it is a violation in regards to an economic offense, my lord, there is a GST plan which has already been pending. Appeal is pending. They are already examining every issue that is available. I have been there since 14/6. I have participated in whatever is possible. Today, why a custodial intervention is required, my lord, to be kept to me, I have not understood. Everything relates is only documentary. Everything. They themselves admit, my lord, that it's all economic offense relating to documents, which I am a defecto. That is their statement. My wife, who is running it, is a proprietorship concern, and I am a de facto manager running the show. And my lord, in the FIR, if your lordship should be kind enough, page 22, it starts at page 20, my lord. Yes, my lord, 22. I just read the second last paragraph, my lord. Page 22. It is further pertinent to mention that Sehbaz Haider, who is the concerned petitioner, Patna, having mobile number so-and-so, is a major coordinator of illegal trade of bitumen on basis of fake invoices and non-existent firms in Bihar, West Bengal, Assam, and exports to Nepal. Sehbaz Haider has floated a firm in the name of Aida Bitumex, so-and-so Kamrup. As per the information, documents relating to fake invoices are maintained by Sehbaz and his brother Naushad. Naushad now has already been released on bail by this honorable court. Such activities severely impact the revenue of the state, particularly in the IGST settlement amounts, which rely on accurate and legitimate interstate tax credit. And fictitious firms not only undermines the integrity of the GST system, but also causes substantial financial loss to the exchequer. So the entire effort is economic offenses. Now, my lord, by including in a financial fraud as such as large, the business entities are not only involved in criminal conspiracy, but criminal breach of trust in manipulating a huge loss to the exchequer. Economic offenses. Fabricating documents, now last line, have also been involved in rampant irregularities. They are irregularities. By indulging and fabricating, forging the documents, as well as by using fake and forged documents to create a genuine fake business. So the irregularity that was created by using a forged document. Now that is a violation in terms of a GST. That's already under adjudication, dispute. I think there's an appeal also being filed, which is pending in regards to that violation. If it is an irregularity, that is what they're claiming to be an irregularity.
Okay.
Just one more line, my lord, just one more line at page 27. This is the order that has been passed by Patna Court, my lord. Page number 2 is Sehbaz Haider, the petitioner before your lordships, my lord. The accused is in an FIR, name is an instant case. The accused so-and-so is a de facto manager of Aida Bitumex so-and-so, which has been found being involved in criminal act of evading fund by generating facts for fake and non-existent taxpayers and taxpayers whose registration has been cancelled so far. The department in various states, in lieu of a non-existence, false and misleading information of registration and other reasons. The investigation report, now the investigation report, my lord, comes into picture. The state GST department has reflected that the GST DRC so-and-so for the financial year 21-22 to 25-26 under order 74A and so-and-so orders and 2020 is annexure supports the charges. Accused is the husband of the proprietor so-and-so. So they have done an investigation and found there is a violation of a GST.
Okay. We'll see whether your further custodial
Objection.
detention will be required.
May I read this statement? Only statement partner. You at least let me have a place the statement made by the petitioner before the investigating authority. The latest one. I have flag marked this, my lord, as Sebas Haider. Just above my lord Binit Potter's statement. Addition.
Yes.
But I would like to state that Binit Poddar, that is the other petitioner, and Rajesh Kumar are my business partners in relation to the bitumen business, and the three of us jointly operate and manage the business activities of Ida Bitumex, Beryl Bitumen, and Assam Bitumix. Binit Poddar, that is the other petitioner, has been associated with me in this business since the year 2022. I also have the knowledge that the firm Beryl Bitumen and Assam Bitumix are in the name of other persons from Kolkata, and we three operate the actual business and the GST affairs of the aforesaid firms. My lordship will mark this one. I stay at Bihar with Sahina and our children and do the purchase related to the firm Ida Bitumex, Beryl Bitumen, and Assam Bitumix. Ajay Yadav was working as a manager and caretaker of Ida Bitumex at Gauhati. He was also managing Beryl Bitumen and Assam Bitumix at Gauhati. He also has a firm named Manisha Enterprise, which is in his wife's name as proprietor. However, the purchase and sales made by the said firms were carried out by me and assisted by Nosar from Bihar. The bank account and ATM card relating to Manisha Enterprise remained in my possession, and I used to undertake the purchase through the said account. Amit Kumar Jha used to come to Patna, where my wife Sahina and I met him. During one meeting, he obtained my wife's signature on 2 blank sheets of paper stating that the same were required for GST related purpose. Also collected copies and details of my Aadhaar and PAN card. Most communication with Amit Jha were done over phone. I had made payment to him only towards proceedings relating to Ida Bitumex, the fees and expenses relating to proceedings. Proceedings means the GST proceedings before the department. Proceedings of the other two firms, namely Beryl Bitumen and Ida Bitumix, were paid by Binit Poddar, Rajesh Kumar. Further, Amit Jha never informed or instructed me to remain physically present during the GST proceeding. That's why I said Nosar is my employee and also a shareholder in my business of Ida Bitumix. I pay him the salary as well as give him some 15% share of the profit generated from the business of Ida Bitumix. He has been working under me for Ida Bitumix since 2001. The local operational work at Patna relating to bitumen business was also looked after by Nosar under my instructions. Sales, technical and accounting related work as well as generation of bill of our business, Ida Bitumix, Beryl Bitumen, and Assam Bitumix were handled by Binit Poddar, the other petitioner, Pintu Sharma, and assisted by our CA, Ayush Kedia, who used to look after all the three firms. Further, Binit Poddar had access to the bank accounts of Assam Bitumix. We also have business transactions amongst ourselves. That is Ida Bitumix, Beryl Bitumen, and Assam Bitumix related to sale and purchase of bitumen. Lordship, this is very serious. The three firms within themselves, they are doing business. That's why, my lord, our report says that, my lord, there is no actual sale at all. No, my lord, transport of any good from, my lord, Bihar to Assam. I make the purchases, whereas Binit Poddar and so used to prepare and arrange bills and transportation. This is the statement of my lord against the other petitioner. I met Manusho. This is not important, my lord. This part, my lord, is very clear. The involvement of both the petitioners, my lord, in the entire case.
Okay.
And my lord, before I, my lord,
I'm just passing it on.
complete it, my lord. Lordship may also, I flag mark it. Lordship may peruse later on, my lord. The statement of my lord, informant Dibya Ranjan Bora. He is a tax official, man. That maybe I have flag mark it. Lordship may kindly peruse that. Entire episode has been, my lord, stated there.
No, Mr. Gogo, you see here the person is behind the bar since 6/8/2026. More than 2 months elapsed. So whether further custodial detention is warranted or not, materials are there, no doubt. That has to be tested during the course of trial.
Yes. Then, my lord, one statement, my lord, lordship may, my humble submission, it is required. I leave it to your lordship. But one para, my lord, of what my learned senior has placed, my lord, the grounds that were cited before the, my lord, before the trial court, when he moved the bail application, One para I would like to read of that, page 80, my lord. It says, my lord, para 9, since the accused Febas Haider is not a permanent resident of the state of Assam, there exists a reasonable apprehension that if enlarged on bail at this crucial stage of investigation, he may evade the process of law and may not be readily available for further examination or confrontation in the light of any fresh or vital facts that may emerge during the course of investigation. His release at this crucial stage is likely to adversely affect the fair and effective.
When that order was passed?
29/7/2026.
29/7.
Yes, he relied upon, that's why I'm placing that para also. Other para
Any
is not
condition
my-
your lordship places, I'm ready to comply with it. There's no problem.
That's the whole issue. My moment he goes to back Bihar, tomorrow my lord to find him, I think.
Most of the accused have been mentioned.
Main
from
being
outside.
one of them,
They are
these
not
two are the
from-
main accused, man. That's why I'm saying.
Okay.
Wife is also is residing in Patna. Most of them have got residences all outside Assam, so they have been.
Okay, we'll say.
Extremely good.
Yes, next item.
Extremely good.
My lord, in this case, my lord, basing on a complaint of the complainant, my lord, additional district magistrate, my lord, draw proceeding under section 145 CRPC and attach the disputed land under 146 CRPC, my lord. Page number 17, my lord. Page number 17, my lord, from second paragraph, my lord. May I read, my lord? Second paragraph.
When this order was passed?
17 to 24, my lord. 17 to 24.
So what is the life of this order?
Hello?
It is usually for how many days?
My lord, in fact, my lord, it's an interim order, my lord, initial order, my lord, and they were asked to submit the written statement, my lord, before the ATM, my lord. But without submitting any written statement, they have approached before the Dalhousie district judge in a revision petition, my lord, which was also dismissed, and Dalhousie district judge directed them to submit the written statement. Then they have come before this honorable court, Article 250, 528, my lord.
Against that order of the district judge.
District judge as well as, my lord, order passed by the ATM, my lord.
So how the order passed by the district judge is illegal or arbitrary? Where is that order?
My lord, order starts from page 25, my lord.
25. 25.
Relevant is page 7 and 8. Your lordship may found it page 27 and 28.
Yes.
The perusal of LCR, including the police report, shows that there is mention about the public breach of peace due to the dispute between the parties in respect of dispute. The court is required to see whether there is apprehension of breach of peace and tranquility due to the dispute of land or not. If the answer is yes, the court below has the jurisdiction to pass the order, and if the answer is no, the court has no jurisdiction. In our case, there is a yes answer as there is a mention in the police report of apprehension of breach of peace and tranquility in the locality due to the dispute. Therefore, in my considered view that the court below has jurisdiction to pass order under section 145 CRPC. It may be mentioned in this context that section 145 CRPC empowers the magistrate to make an order in writing stating the grounds of his being satisfied either from the report of a police officer or upon information that the dispute likely cause breach of peace exists concerning any land within his local jurisdiction and requiring the parties concerned to attend his court and to submit the WS in support of their respective claims, and no hard and fast rule can be laid down as to the sufficiency of materials for the satisfaction of the magistrate, and it must be construed from the facts and circumstances of a particular case. In the case at hand, as stated above, police report shows that there is mention about the public breach of peace and tranquility due to dispute and the loss of life. Since it is the duty of the state to protect, uphold the law, the court below has not committed any errors while passing the order impugn. Para 8, my lord. In view of the above discussion, the court below has correctly passed the impugned order. I hereby upheld the same. However, with regard to the attachment, the revisionist is directed, that is the present petitioner, my lord, directed to file appropriate petition before the court below, praying for withdrawal of the attachment that was passed under section 146 CRPC. The court below, after obtaining fresh police report and hearing the parties dispute of the dispose of the petition as per law. So the learned session has already directed them to approach before the learned court. Instead of this, my lord, they have approached before the this honorable under.
Why don't you file the written statement there?
My lord, I have challenged, my lord, here, my lord, on this ground, my lord, paragraphs number 11, my lord, condition. This is the
11 of?
Page number 11, my lord. This is the complaint petition, my lord. Page number 11, type copy, my lord. Last paragraph, my lord. Currently, I, the complainant, and my brothers residing in Konakpur, Part 1, Silchar, and my two other brothers residing at Shillong, Digboi, along with their family members. My lord, the family members and the complainant are residing beyond the locality. They are not residing within the locality of the disputed land. So there is no breach of peace and tranquility, my lord. As per so since they have already admitted they are residing outside, so there is no breach of peace, my lord.
No, maybe. Since this order was interim order.
Interim order, my lord. So, in fact, my lord, article section 258, my lord, interim against the interim order, criminal petition is not lies, my lord, since they have to approach before the learned magistrate first, my lord. And learned session just rightly rejected their petition, my lord, and directed them to appear before the
against the revision of order of criminal revision petition, my lord, I have come before this court. I am not.
No, maybe, but the original order is interlocutory order. So whether revision will lie, if the revision does not lie, then this petition is also not maintainable.
Yes, my lord.
On that ground.
And I am challenging the, my lord, order of revision, my lord. Criminal revision petition, my lord.
Revision as well as order dated 7/2/24. In his prayer, my lord, your lordship may kindly page 8 and.
Since, my lord,
they have to approach before the learned magistrate, my lord.
My lord, I have already filed one petition, my lord, my lord.
Before?
Before the additional district magistrate, my lord. But till date it is not yet considered, my lord. 201/2025.
That is a different aspect. But this petition, whether it is maintainable, where.
My lord, I have also submitted the affidavit, my lord, regarding the maintainability of his petition, my lord. In fact, as the interim order, my lord, the learned district magistrate has passed the order, my lord. Let them, my lord, appear before the district magistrate and submit their written statement, which you have already submitted.
No, when your remedy is available before the court below, then you cannot avail this remedy. 528.
Generally, my lord, I have come against the order of revision, my which is passed by the session judgment.
How the order of session judge is wrong?
Wrong, my lord, there is no possibility of breach of peace and tranquility, my lord.
Whether the revisional court can determine the same, that is a factual aspect of the matter.
Yeah.
In revision, the courts only examine the legality, propriety, and correctness of the order. The court cannot go into the facts. Appreciation of fact is the business of the trial court, the district magistrate. How the order of the trial court is, session judge is illegal then? Whether there is a breach of tranquility and peace. That is the factual aspect to be determined by the trial court after examining the witnesses.
And my lord, till date, my lord, nothing happened, my lord. I have filed on a petition, my lord, in the additional.
That is a different matter. If he has not been the executive, no, the district additional district magistrate has not been doing anything, then you can approach this court by filing a petition under Article 227. One decision is there, the Madhulimai decision, Madhulimai's case. As per that case, revision petition is not maintainable against interlocutory order.
Yes, my lord.
To find out those decision, we will list the matter again on 8th of September.
Okay.
Heard, Mr.
F.L. Osman.
Learned counsel for the petitioner, and Mr. Alam, learned counsel for the respondent number. Sole respondent.
Sole respondent.
Sole respondent. Heard in part, list the matter on 8th of September.
Obliged.
Any other matter?
Coming item 16.
So your senior is in Lakes.
Input number 22, the argument hearing is going on, my lordship. So give a short date, my lordship.
So the other side has been waiting since morning.
Actually, hearing is going on, not yet finished, my lordship.
On your pair, the case is listed today.
For admission, hearing, this petition is filed for requesting of the order of framing of SARS and as well as the proceeding of PRC case number, PRC case.
May I please your lordship? Lordship, on the earlier occasion, scanned copies of the entire case record and CD was called for. Lordship, scan copies are there, lordship, and moreover, if your lordship remembers, already hearing has been done that day, lordship.
Pardon?
Hearing has been done on the earlier occasion, lordship, and just lordship wanted to see the CD before passing on any necessary order, lordship. And adjourning today, lordship, it's nothing but languishing the case, lordship. And moreover, they are on they are on stay, lordship. Stay order has been received by them, lordship.
Okay, let her senior appear, argue the matter.
Okay. Lordship, a short date may be fixed.
So that next 2 weeks, this court will not be sitting here, only in the second week of September. Take a date from him. Heard, Ms. Begum, learned counsel for the petitioner, and Ms. Swinso, learned counsel for the respondent. Ms. Begum submits that conducting counsel, Mr. Kotoki, is in Lakes in another court. And as such, a pair has been made for adjournment of the matter for the day. Pair allowed, list the matter on 10th of September. Interim order pass earlier shall continue. It is, however, it is made clear that no further adjournment will be granted in this matter.
17 is the same.